వచ్చేసారు.
సార్ మేడం కూడా వచ్చేసారు, విజయలక్ష్మి మేడం కూడా వచ్చేసారు.
మేడం గారు కూడా వచ్చారు.
బాలస్వామి గారు కూడా
మేడం, it is the time now to start. Shall we start? Principal madam. Hello. Madam garu.
చేయండి సార్. ఓకే సార్.
స్టార్ట్ చేసేద్దామా? అందరూ లైన్
we
లోకి
can
వచ్చేయండి.
start sir. ఓకే.
Good morning, all of you friends. Today we are going to conduct a national webinar on intellectual property rights, which is the need of the hour. Generally, our college always takes very important and significant topics for consideration of conducting webinars. Fortunately, last time we have conducted a national webinar on COVID and the various aspects of COVID, how the COVID deprived various sections of the society. We got a tremendous response in that webinar, and now we thought of conducting a national webinar on intellectual property rights, which is the need of the day. For this, we have invited legendaries, excellent personalities like Professor G.B.Reddy garu, who is going to deliver a keynote address, Professor Vijayalakshmi madam from Andhra University, Professor B.Balaswamy garu from Osmania University, and now I welcome all the dignitaries, participants, academicians, researchers and students to this webinar, and I request our principal to chair this session. Before we go into the further proceedings, may I request our principal to proceed further. Thank you very much.
Thank you sir. Am I audible? Thank you. Panel of experts, Professor G.B.Reddy garu, College of Law, Osmania University, Hyderabad, Professor V.Vijayalakshmi garu, Dr. Ambedkar Open University of Law, Andhra University, Visakhapatnam, Professor B.Balaswamy garu, Department of Journalism and Mass Communication, Osmania University, Hyderabad, academicians, researchers, students, ladies and gentlemen. I am pleased to welcome you to this virtual conference. I thank you for taking time to join us in this meet. The webinar aims at creating awareness about the increasing significance of intellectual property rights in global perspective. IPR refers to any intellectual creation of mind. IP laws give people the right to own and profit from their artistic, scientific, and technological creation of mind for a designated period of time. Today, we are living in the midst of information revolution. IP is the result of conversion of knowledge into a commercially exploitable potential. It is for the betterment of all nations that we promote IPR. Societies where such rights are safeguarded alone can witness cultural advancement and economic progress. Major software giants like Google and Microsoft have become the richest persons of the world in a very short period of time through their intellectual assets. While India made the tremendous progress in enhancing protection and enforcement in some areas, it is unable to resolve recent and long-standing challenges. India continues to remain on the US Trade Representative's priority watch list for alleged violation of IPR. In its latest special report, that is 301 report 2020 by the USTR, India is termed as one of the world's most challenging economies. Foreign investors and MNCs also allege that Indian law does not protect against unfair commercials of data submitted to the government during the applications for market approval of pharmaceutical or agrochemical products. Furthermore, enforcement of the Copyright Act is weak and piracy of copyrighted materials is widespread. However viable an IP legal system is in place, the society will benefit only when it is well informed. As a step towards promoting innovation and creativity, especially amongst entrepreneurs in higher education, IPR cells, incubation centers are established in degree colleges and universities to create awareness among rich students and also research scholars to encourage also creativity and then innovative spirit of the young generation. The UGC identified IPR as a generic elective subject under CBCA system. NIRF also ranking system also adopted by Ministry of Human Resource Development gives weightage to IPR and patents while assessing the performance of the institutions, which led to considerable increase in the number of applications filed for patents. The budding professionals, entrepreneurs, and other stakeholders need more information and orientation protecting their intellectual power. Experts believe that the foundational awareness regarding the rights of a creator needs to be developed in students from the school level itself. Then the annual review of the international patent system administered by the World Intellectual Property Organization claimed that only 6% of patent cooperation treaty applications originating from India were filed by universities in 2018. This implies that young researchers need to know more about IP rules and rights. It is in this context today's webinar gains relevance. I recognize some familiar names of participants from our government colleges, and I am sure we are also reaching out to many new friends, innovators, and civil society representatives. And I also am thankful to our expertise panel of speakers who joined our meet today. I congratulate the Departments of Political Science and Commerce for organizing the webinar on IPR, which is immensely relevant to all sections of societies, which is hitherto only allied. I am hopeful that this virtual platform will generate meaningful discussions and will provide rich insights on the theme. Thank you. Now I hand over proceedings to Dr. P. Sai Babu. Thank you.
Thank you very much, madam. In fact, our madam is an all-rounder. She has presented a very good aspect in her opening remarks. May I request Mrs. Lakshmi, the head of the Department Commerce, to give the brief introduction about the seminar.
Good morning all. It is my pleasure to welcome everyone to our today's national webinar on intellectual property rights. This is Lakshmi, working as lecturer in commerce, Sri DNR Government College, Palakollu. Now, I would like to present a brief introduction about today's webinar on intellectual property rights. Intellectual property is generally defined as intangible creations of the mind which may be protected under patent, copyright, and trademark laws. Inventions that can be protected by patent law include new or improved versions of processes, machines, and compositions of metals that are used, and new distinct plant varieties. Works of authorship fixed in any intangible form of expression may be protected under copyright law. These may include literary works, sound recordings, computer software, photographs, and musical compositions, etc. A trademark is any work, name, symbol, or device used by a person to identify and distinguish goods, including a unique product from those manufactured or sold by others, and to indicate the source of the goods. And also, public institutions and colleges are among the direct contributors towards innovation and research, particularly in emerging economies. The IPR policy of India focused towards promoting innovation and creativity, especially amongst entrepreneurs and in higher education institutions. The University Grants Commission also issued a letter for inclusion of the intellectual property rights as a generic elective subject under the choice-based credit system. In addition, the NIRF ranking acts as mechanism for the institutions to include promoting innovation, research, and development while assessing their performance beyond academics. Hence, there is a need to spread awareness about intellectual property rights among students, researchers, and also academicians. On the nature of rights, what they protect, and how they are how they best be commercialized, and also career opportunities. I hope today's webinar will enrich the knowledge to all the participants. On this occasion, I would like to invite honorable research today's Professor G.B.Reddy sir, Professor V.Vijayalakshmi ma'am, and Professor B.Balaswamy sir to address the participants. With this introduction, now I am handing over to our principal. Over to you, ma'am.
Thank you, madam. Thank you very much for your brief introduction of this seminar. We are entering into a very important moment. Now, before we listen to Professor Reddy garu, who is a legender of this legal aspects, particularly who is a combination of a rare combination of both practitioner and also a theoretician. Now, may I request Mr. Lakshmi garu to give brief introduction about Professor G.B.Reddy garu, so as to enable our participants to know about the legendary personality of our keynote address. Madam Lakshmi garu.
Okay, sir. I have immense pleasure to introduce Professor G.B.Reddy College of Law, Osmania University. Professor G.B.Reddy sir is a lawyer turned academician, studied BA, LLB, and LLM at Osmania University and PG diploma in human rights at the University of Hyderabad. Obtained PhD in law from Osmania University in 1999 on the topic Supreme Court and Judicial Activism. Its contribution in specific areas of constitutional law after 1980. His area of specialization is constitutional law in LLM and judicial activism in PhD. He specialized in the area of intellectual property as an independent researcher, publisher, and teacher. He had a brilliant academic record with 3 gold medals in LLB and 1 gold medal in LLM. Apart from being the first candidate to have qualified for UGC JRF in law from Osmania University in 1993. He practiced in the High Court of Andhra Pradesh for about 7 years before joining the Faculty of Law, Osmania University. Sir authored 20 well-received books in law, including Main Intellectual Property Law, Copyright Law in India, Practical Advocacy of Law, Right to Information and Law, and Judicial Activism in India. 2 of his books, namely Women and Law and Judicial Activism in India, have been reviewed favorably in the book review section of Hindu by V.R. Krishna Iyer. He also published 56 articles on law published in standard national and international journals. He has been a contributor on environmental law to the annual survey of Indian law published by the Indian Law Institute since 2013. As principal, University College of Law and head Department of Law, University, Hyderabad, 2005-2008, during which period he contributed to the university to introduce LLB, 5 years integrated course at the University College of Law. He has been a visiting faculty at several reputed institutions, including the AP Judicial System, AP Excise Academy, Andhra University of Law, National Industrial Security Academy. He is at present the chairperson Board of Studies Osmania University since 2007. He is the director. At present, he is the director. He was the founder director of the legal cell of the university. Direct legal cell of the university from 2015 in the capacity from 2015 to 2016. He was appointed as a member of General Council of Andhra University of Law, Hyderabad. He is a life member of the Indian Law Institute and the Institute of Constitutional and Parliamentary Studies, New Delhi, and the American Studies Research Center, Hyderabad. With these few words of introduction, I request for further proceedings.
Thank you very much, madam. It is really an immense pleasure to have Professor Reddy garu in our platform. I am in fact a man extensively on law and all a thesis on judicial is a challenging and also a courageous work. Generally, uttering a word about judiciary sometimes creates a lot of problems. But Professor Reddy garu writing particularly on judicial activism, particularly court, it is in fact an adventurous work, a courageous work.
నెట్ కనెక్షన్ కరెక్ట్ గా లేదు అని మెసేజ్ పెడుతున్నారండి. వాయిస్ క్లారిటీ లేదు.
Is it audible, please? Hello.
Sir, okay, sir.
Okay, na Subramani garu, just you take care. In fact, such a great personality who is a member in many organizations which are having prior importance today is addressing our national webinar, particularly with this keynote address. I hope all the participants and the students particularly will be benefited, richly benefited with his keynote address. Thank you, sir.
Thank you.
You are having in our midst, particularly on this virtual platform. I request Professor G.B.Reddy to deliver his keynote address.
Thank you, sir. Very good morning to all of you. Uh, I'm very happy to be with so many senior faculty members, colleagues, and enterprising students of the Dasar Narayan Rao Government Degree College for Women. I think we have to remember, of course, you do remember every day, but as a fan of late Sri Dasar Narayan Rao Garu, I'm very happy to say some meaningful words about intellectual property rights in the college named after him. Sri M.M. Nayak Garu, the chief patron, the Honorable Commissioner, Collegiate Education, Government of Andhra Pradesh, Professor Nagamani Ma'am, Principal of the DNR Government Degree College for Women, my fellow resource persons, respected Professor Vijayalakshmi Ma'am, Professor of Law from Andhra University, Professor B.Balaswamy Garu from Department of Journalism and Mass Communication from Osmania University, and Professor Saibab Garu. In fact, he was the one who contacted me after Professor B.Balaswamy Garu spoke to me, head Department of Political Science, Mrs. S. Lakshmikantam Ma'am, HOD Commerce, and Mr. Subramanya Garu, Technical Advisor, and dear students. I'm very happy to be with you this morning and to say something probably meaningful about Medo Sampatti Hakkulu, intellectual property rights. And I must thank the organizers for giving me this wonderful opportunity. In fact, about 20, someone made a statement about the richest person being a knowledge worker and not an oil worker. When Bill Gates became the richest man in the world, an economist wrote a thought-provoking article. Of course, he also made some critical remarks against India, as pointed out by the Honorable Principal Ma'am in her opening remarks, that whatever India has done is only by copying, not only by catching up, not by creating something original. So that feeling still persists, even after quarter of a decade, a century, 25 years, because the Western world is not totally prepared to accept that India is a country capable of creating intellectual property. In fact, we have created this kind of property much before they even thought about the intellectual property and intellectual property rights. But what we have to understand, dear students, today is that the saying that knowledge is power is an old saying today. Knowledge is property is the new saying. The human knowledge, the human intellect can be converted into property. That is how Bill Gates could become one of the wealthiest men in the world today. That's the reason why we take some of the names with utmost reverence, whether it is J.K. Rowling, whether it is someone else. This is one important point. And I would like to inform you that today knowledge plays a very important role. This century is known as the knowledge century of knowledge revolution. Last century, probably you can call it the century of information revolution. Go back, it was the century of industrial revolution in 19th century. But over a period of time, we have realized that intellectual property has converted the centuries into knowledge revolution century of knowledge revolution. This is one important point. I would like to draw your attention to the vision statement of the National Intellectual Property Policy, which was released in 2016, which categorically says that we are looking at India where creativity and innovation are stimulated by intellectual property. That is creativity as well as innovation, both of them. Then for benefit of whom? For the benefit of all. Again, the policy states that in India where intellectual property promotes advancement in science and technology, not only science and technology, arts and culture, traditional knowledge, biodiversity resources. And the last statement, I'm just quoting a small part of this policy. And the last statement in this sentence is that in India where knowledge is the main driver of development. Today, knowledge is going to be the main driver of development, and knowledge owned is transformed into knowledge shared. That is, owning the knowledge is not sufficient. We must transform the same into knowledge shared. You know very well, knowledge gets multiplied once we share with the others. This is one important aspect. Then you look at some of the, in fact, modern knowledge workers, whether it is Bill Gates, whether it is J.K. Rowling, the author of Harry Potter series, or just look at, in fact, Michael Jackson. Michael Jackson, there is something related to Michael Jackson and intellectual property. Performer. But when he was performing, he used to perform a moonwalk, and that moonwalk reflected Michael Jackson and all his troupe members leaning forward by 45 degrees without falling down. If we try this, we will end up with a flattened nose. But they didn't fall down. You know why? There was something related to intellectual property. The shoes which were worn, used by Michael Jackson and his troupe members, they had a technology which prevented those people from falling forward. It was patented by Michael Jackson, but it wasn't renewed. But this is the example. Today, you are talking about authors making so much money. Like J.K. Rowling, at one point of time, her income was around £5 per second on the royalty she used to get from the sale of her books or the movies made based on her books. Bill Gates today, no doubt, is one of the wealthiest persons. It's only because of commercial exploitation of intellectual property. The software, the computer software today, which is protected mostly by the copyright and other computer related inventions which are exploited, and the rest is history. What I am trying to say is that today everything is revolving around knowledge, knowledge industries, knowledge revolution, knowledge economy, knowledge management, and the traditional property is taking a back seat. Knowledge is taking the front seat. This point also you must understand. Then another important aspect which I would like you people to remember is that about intellectual property, the previous speakers have already explained few important aspects. We are talking about a property, nothing like building or a bench car or movable, immobile. Just forget about it. We are talking about a property which doesn't have a physical form, which is in the form of information, technological information, scientific information, expressive information, ornamental information. And if this information is the result of human creativity, you will not, find the same in a physical form. You are buying a new book, students. Wonderful book published by Oxford University Press. When you are buying that book, you are not buying the intellectual property in the book. You are buying only hard copy. The real intellectual property is in the form of copyright. Copyright is retained by either the author or by the publisher. That is another important aspect. Please try to understand. You are buying the latest, iPhone Pro, 12 Pro or 12 Pro Plus, something like that. People are ready to spend 2 lakhs also. Doesn't matter. There is a latest technology involved in it. It may be patented. When we are buying a new mobile, we are not buying the patented technology. We are buying only a piece. The patent is still held by the company. What I am trying to say is that same is the case with any brand. We are purchasing branded goods, availing branded services. We are not owning the brand. Brand is still held back by the owner of that brand, the trademark owner, whoever it is. So ultimately, intellectual property is in the form of rights, hakkulu, legally protected interests. Those rights are called by different names. They can be created in different fields. Don't think that it's only science and technology. I'll give you a few live examples to showcase the fact that a person who is not formally educated also can create intellectual property. I'll give you that. For example, the knowledge can be created in the field of science, industry, literature, art, and the intellectual property in the form of rights can be seen as patents, copyright, trademark, design, GI, Gunturu Sannam, Mirapa. గుంటూరు సన్నం మిరప మేము ప్రతిరోజు యూజ్ చేస్తా ఉన్నాం, మాకు స్పెషల్ ఏం కాదనొచ్చు మీరు. Now it is a GI, geographical indication of goods. It is already registered, friends. Tirupati Laddu is a GI. That is also intellectual property. Don't think that intellectual property is created only, within the four walls of laboratories and R&D institutions. In our day-to-day life also, we create, we use, we share, we exploit intellectual property in different forms. Traditional knowledge. For example, the other day I watched a very interesting video. In Bombay, there is a particular kind of dosha, flying dosha. You must have watched it on WhatsApp or elsewhere. The person, creates the dosha, then just, flings it into the air. It lands in a plate. Flying dosha. But who prepared the dosha for first time? Everyone eats with lot of, liking. But who made dosha for the first time? Idli for the first time? Sambar for the first time? Chutney for the first time? In fact, is there any training institute to make these, different recipes? Maybe hotel management institutions are coming into existence nowadays. In the good old days, it was grandmother's recipe, and which transformed or got transmitted from one generation to other generation. That is also intellectual property. You can call it traditional knowledge, indigenous knowledge. And what I am trying to say is that intellectual property is not related only to science and technology. It is related to other disciplines as well. We are talking about a multidisciplinary subject. An Urdu poet or scholar or teacher or student, same is the case with Persian, same is the case with a journalist, same is the case with an architect. Everyone has some concern with the intellectual property, because once something is created new by using the human intellect, and if it is original, it acquires the shape of intellectual property, giving certain monopoly rights to the creators as well as the owners. The monopoly rights are given. Here I would like to explain. See, our grandparents or parents must have earned a lot of properties, and now they are passing them on to us, and we can keep them or we can transfer them to others. There is no fixed shelf life. We can't say that if you are purchasing a house, you can own it only for 10 years. After that, you must transfer. Nothing like that. But in the case of intellectual property, generally it has a limited shelf life. Bill Gates said that intellectual property has the shelf life of a banana. How can you keep the banana good forever? After some time, it gets rotten. Its shelf life is hardly, uh, hardly, in fact, it may be kept safe or intact maybe for 3 days, 4 days, 1 week. After that, it gets rotten. Same is the case with intellectual property, because once it is created, it may be under the exclusive control of the creator or owner. But after it is registered, then after lapse of a certain period of time, it comes into public domain. Penicillin was invented by someone, Alexander Fleming or someone else. Today, his family doesn't own anything related to penicillin. The knowledge has come into public domain. Same is the case with any other invention. If it is a patent, it has a limited shelf life for 20 years. If it is a copyright, it may be only for maybe lifetime of the author plus 60 years after his death, as far as India is concerned. If it is an industrial design, it will be protected only for 10 years, unless extended by 5 more years maximum. If it's a geographical indication, it must be registered and it will be in the private domain for 10 years, then it must be renewed every 10 years. Same is the case with trademark. What I'm trying to say is that there are two domains in intellectual property. One is private domain, the other one is public domain. Private domain is the period during which the author or the creator or the owner can enjoy certain rights to commercially exploit those inventions, those literary works, artistic works, industrial designs, etc. But once this time period is over, it is everybody's property. Take the case of COVID vaccine. We don't know whether the patenting is going on or not, because people are more worried about life saving now. But whether it is Covaxin or something else, if it is patented, after 20 years from the date of patent, it will come into public domain. Anybody can make use of it. Whether it is Serum India Limited, AstraZeneca, or Oxford University or Bharat Biotech, they will not have any control over the patented medicines or vaccines once that 20 years term is over. Then it becomes everybody's property. This is intellectual property. Please try to understand that intellectual property is shaping the destiny of the nation. Yesterday, I was having a word with one of the senior professors. He was saying Nokia company used to take care of the entire financial needs of a country like Finland at one point of time. Nokia. Then disruptive technologies came and its importance came down. That's a different issue. But intellectual property can shape the destiny of a nation, either in the matter of creation of wealth or commercial exploitation of these inventions, so on and so forth. One more, introductory observation, then I will go to the specifics. Intellectual property has some unique characteristics. 1, 2, 3, 4. First one is it is intangible property, as pointed out by one of the previous speakers, which can't be touched, sensed, perceived, or physically possessed. Second one, it is a result of mental labor, human mind, intellectual creativity. Third one, it is in the form of rights. You can't see those rights, but you can call them patents, copyright, trademark, design, etc. Fourth one, intellectual property confers limited monopoly rights. Means, you can enjoy the monopoly only for a fixed period. Last point, intellectual property is something which cannot be kept in a country confined to a safe deposit locker. Means it is transnational in character, across the state boundaries. అమెరికాలో ఎక్కడో ఎవరో ఒక చిన్న పద్యమో లేకపోతే పోయమో రాసి, if it is uploaded on the world wide web, it can be accessed anywhere in the world within few seconds. నా కాపీరైట్ పోయింది అని మొత్తుకుంటే లాభం లేదు, because for the simple reason that intellectual property rights are transnational in character. That is the precise reason why the owners, the creators, they must take steps to protect the intellectual property, not only in the country of origin, but wherever it is going to be exploited, in whichever country it is. This is something relating to intellectual property, friends. Then coming to for example, take the case of a cell phone. I think it will be easier to understand. Do you think that any intellectual property can be seen in a cell phone? The brand name of the cell phone, Apple, Samsung, Redmi, whatever it is registered as a trademark. So that is one intellectual property. The design of the cell phone, the screen, the camera, whatever it is, the placement, the shape, the configuration, the pattern, that is in an industrial design. Technology is used in the cell phone, right? So for the purpose of operability and all, there you come across patent for the technology used in the cell phone. Then you must have watched the movie Arya 2 or Arya 1, చూసుంటారు మీరు. కాజల్ అగర్వాల్ ఏం చేస్తుంది, కోపం వస్తే సెల్ ఫోన్ పగలగొడుతుందా, 1 or 2 నాకు జ్ఞాపకం లేదు. If you break open the cell phone, what can be seen? You will see the chip, SIM card, layout design, semiconductor and integrated circuit layout design. That is also intellectual property. There is a particular ringtone used in the cell phone of a particular company. The ringtones can be copyrighted. The information booklet, the instructions, etc., they can be copyrighted. Means if you look at one cell phone, friends, 5 different kinds of intellectual property can be seen: trademark, industrial design, patent, layout design, and copyright. And similarly, in our day-to-day life, we come across intellectual property in almost every sphere of human life. We keep on using without realizing. Take the case of branding. మీ హెయిర్ పిన్ దగ్గర నుంచి చెప్పుల వరకు, every goods, every subject matter of merchandise has some kind of intellectual property. Brand name అయినా ఉంటుంది, at least trade name, trademark, right? Design, etc. This is another important aspect. Now, as I already mentioned, there are different forms of intellectual property rights. There are patents, copyright, trademark, design, then trade secrets, geographical indications, so on and so forth. And maybe the other 2 resource persons will throw sufficient light on the areas chosen by them. Therefore, I don't want to encroach upon their domain. However, a brief introduction may be given. What is a patent? For instance, recently we have seen a farmer from this Mechal Malkajgiri area near Hyderabad claiming that he has invented a new variety of rice which is less in carbohydrates. Therefore, sugar and other patients also can happily eat that rice. And he says, I already got a WIPO patent. At least some process is on, World Intellectual Property Organization. So what is patent? Patent is a limited monopoly right given to an inventor for making an invention. Innovation is different from invention, friends. Please try to understand. Innovation may lead to invention, but innovation may also lead to many other things like a new business method, etc. So patent is a limited monopoly right granted to the inventor or the owner of invention in respect of that invention, whichever is the invention. It may be vaccine, it may be some kind of a new machine, whatever. If 3 conditions are satisfied: novelty, utility, and non-obviousness. And let me tell you, patenting is not exactly a costly affair. At the same time, it is not so cheap. So one requires 30 to 40,000 rupees at least to make an application in India. But there are number of organizations which are coming forward to help those coming out with new inventions patent their inventions, such inventions. Trademarks, you know very well, some mark which can be seen, which may be in the form of a letter, number, alphanumeric, right, a shape, etc., etc. Because see, there are so many students in DNR Government Degree College. Each one of you, I think, has a name. Same is the case with goods in the market. When similar goods are released into the market, they must have different names if they are produced by different companies. That is trademark. Whether it is Hammam, Lux, like Boyer, Liril, or whatever it is. As far as the soaps are concerned, all of them are trademarks. You have the application of these marks in respect of so many things. Designs, for example. Design is normally something which is very attractive in goods, which can be, in fact, uh, you know, something which is appealing to the eye and judged only by the eye. That means whether it is useful or not, we don't care. Design attracts our eye, and such features like the shape, configuration, pattern, all of them can be registered as a design. GIs, for example, goods are of different types. Like, we have agricultural goods, we have manufactured goods, natural goods. They may be coming from different areas, manufactured in different areas, but some unique characteristics, special features, quality, quantity, appearance, etc. They may be because of geographical factors. భౌగోళిక పరిస్థితుల దృష్ట్యా వాటి క్వాలిటీ అనేది మారుతూ ఉండొచ్చు. నాగ్పూర్ ఆరెంజ్ అంటారు. ఆరెంజెస్ ఆర్ గ్రోన్ ఎవ్రీవేర్. నాగ్పూర్ ఆరెంజ్ ఈజ్ సంథింగ్ స్పెషల్, ఎందుకంటే కొంచెం సైజ్ పెద్దగా ఉండొచ్చు. దే మే బి మోర్ జ్యూస్ అండ్ ఆల్. ఇట్ ఈస్ బికాస్ ఆఫ్ ద క్లైమాటిక్ కండిషన్స్ ఇన్ నాగ్పూర్ ఏరియా, రైట్? తిరుపతి లడ్డు ఉంది. తిరుపతి లడ్డు గురించి కూడా చాలా డిస్కషన్ జరిగింది ఒకప్పుడు, రైట్? But when you are talking about Tirupati laddu, it was given a geographical indication, because that kind of laddu is never, in fact, manufactured in other parts of the country or state, right? That is another important aspect. Then you have the copyright. Copyright is not right to copy. మన పిల్లలు చాలా చిలిపి. కాపీరైట్ ఏంటంటే రైట్ టు కాపీ అంటారు. నిజంగా చెప్పాలంటే రైట్ టు కాపీ కూడా కరెక్టే, బట్ ఏంది కాపీ చేసేది? రైట్ టు కాపీ వన్స్ ఓన్ వర్క్. ఇఫ్ ఐ రోట్ ఎ బుక్, I have the right to reproduce that book any number of times. That is my copyright, right? Right to translate it, right to communicate it to the public, right to publish it, right to assign the copyright. ఇవన్నీ copyright లో భాగం. పరీక్షలో కాపీ కొట్టడం కాదు. That is also an intellectual property in respect of literary works, artistic works, musical works, ఇవన్నీ ఉంటాయి. Plant varieties, for example. Just now I mentioned about Mr. Venkat Reddy from Mechal Malkajgiri district. He says that he has invented a new kind of plant variety as far as rice is concerned. He says, I am an agricultural scientist and I already got patents for other varieties. This is, the new variety. If these new plant varieties are created, for example, brinjals, మీరు కూరగాయల మార్కెట్కి వెళ్తారు. How many kinds of brinjals you come across? Kanisam 10-15 different kinds you must have seen. And they are the result of some kind of, innovation in biotechnology, in plant and molecular biology. Ivanni. Net result is that you have blue, you have green, you have red, all kinds of brinjals. Some are lean, some are fat, some may have proteins, some may not have so many proteins. And some may be taking only short time for growing, some may be taking longer time. But that is also intellectual property, friends. They are protected for 15 to 18 years. So there are so many other kinds of intellectual property which you need to keep in mind. But what you need to understand is that all kinds of intellectual property is not relating to science and technology. This may be mostly in the case of industrial property, like patents. They are given to inventions. Inventions may be mostly in the fields of science and technology. Trademarks. తెలుగులో మహాకవి చెప్తారు శ్రీశ్రీ, కాదేది కవిత కనర్హం, కుక్కపిల్ల సబ్బుపిల్ల అగ్గిపుల్ల అని. పేటెంట్ కూడా ఏది అనర్హం కాదు. యూ కెన్ టేక్ ఎ పేటెంట్ ఈవెన్ ఫర్ ఎన్ ఆల్ పిన్, ఈవెన్ ఫర్ ఎ టూత్ పిక్, provided it is novel, useful and non-obvious, right? Then trademarks, industrial designs, geographical indications, even industrial property category lo vastayi. Then we have literary property, something relating to literature, culture, heritage, like, especially when the human mind creates new literary work, prose, poetry, fiction, non-fiction, ఏదైనా కావచ్చు, original work or derivative work. Take for example, Ramayana antam. Ramayana anagane different persons have written Ramayana and its interpretations, different interpretations. Each one of them will have copyright in Ramayana. Then same is the case with artistic works, then the musical works, cinematograph films. Late Dasa Narayan Rao Garu, he was a multifaceted personality. He was a script writer, he was a story writer, he was a, in fact, a lyricist, he was an actor, he was, in respect of each of those things, there was copyright. Cinema law, because we say something like, convergence of copyright. Every work lo wala copyright ఉంటుంది. సినిమా పాట లిరిక్స్ రాస్తే దాని కాపీరైట్ ఆ లిరిసిస్ట్ ఉంటుంది. Then if somebody composes music, Ilayaraja, A.R. Rahman, they will have copyright in their musical work. If there is a cinematography, Gopal Reddy, ఎవరో Chota Naidu అంటుంటారు, వాళ్ళకు ఉంటుంది automatic. So there are so many other aspects, but a cinema producer gets them assigned in his favor. అప్పుడు ఏమంటామంటే it is convergence of copyright. వాళ్ళందరికి పే చేసి an agreement రాయించుకుంటారు. Right? That is copyright. Copyright can be claimed in literary works, artistic works, musical works. ఇవన్నీ చెప్తారు, బహుశా విజయలక్ష్మి మేడం చెప్తారు. Then we have other new variety, even neighboring rights. This is important. For instance, there are any number of FM radio channels. In respect of each of them, there is a right called a neighboring right. You can say broadcast reproduction right, TV channels, radio channels, etc., etc. Performers have certain intellectual property. A performer is somebody who gives a live performance, maybe an actor, maybe a singer, maybe some other performer. If it is live performance, if it is something original, he will have a right known as performer's right. Without his permission, it can't be recorded, it can't be telecast or broadcast, or re-telecast or rebroadcast. These are all neighboring and related rights. Apart from this, you also have other emerging forms of intellectual property, friends. Plant varieties protection, I have already explained. Life forms are protected. In 1988, a mouse which was created under laboratory conditions in Harvard University, Harvard medical school, it was called Onco mouse, ONCO, Onco mouse, and a cancer related mouse for the purpose of conducting research. So Harvard Onco mouse was nothing but, a kind of intellectual property, and it was patented. Genetic resources and traditional knowledge is intellectual property. Layout design, I already explained. Business methods, computer programs, so on and so forth. Microorganisms also can be, in fact, the subject matter of intellectual property protection. So what you need to understand is that many countries in the world realized the commercial importance of intellectual property only after 1994. That is, after the TRIPS agreement of the WTO, World Trade Organization, brought into existence agreements. One of them is TRIPS, that is Agreement on Trade Related Aspects of Intellectual Property Rights. And this TRIPS agreement, for the first time, made different nations, not only the developed nations, but also developing nations and the least developed countries, realize the importance of intellectual property. Of course, they wanted to protect these intellectual property rights as private rights, and they wanted to have some kind of level playing field in all the countries, developed, developing, and least developed. And the policies of respective countries, which are members of WTO, the legislations, legal regime, all of them changed after 1995. Even in India, the awareness about intellectual property was not so much before 1995. It has increased post TRIPS. This point is one. Then we have number of other aspects which we need to understand as far as the intellectual property is concerned. Like the West has realized its commercial importance long time back. Countries like India's realized only after 1990s. Though we had respective laws, policies, so on and so forth, but we thought that knowledge must be free. Like Rabindranath Tagore, who said that where the knowledge is free in Gitanjali. So we wanted knowledge to be freely shared. But today it's not possible probably, because everyone wants to purchase knowledge. Knowledge is never free. Anyway, this is one important aspect. Number of new developments are coming in the field of intellectual property. Today, as pointed out by Sam Pitroda in his report submitted under the auspices of National Knowledge Commission, he says that intellectual property must come out of the universities, must come out of the R&D institutions. It must reach every nook and corner of the country. So educated, semi-educated, then skilled, semi-skilled, etc., etc. It can be created by anyone, friends. Please try to understand, right? Small example. I had a very pleasant experience of sharing a dais with a gentleman. I don't remember his name. Sometime in 2005 or 6 in Nasik, Maharashtra. And I was a resource person. That was a seminar on intellectual property rights. The session was after lunch. Then one gentleman, very ordinary looking person, not so well dressed, he was sitting on the dais by the time because others were gathering slowly. Then I asked him, sir, who are you? Are you one of the organizers? He says, no, I am not an organizer. Then who are you? Then he says, in fact, I am one of the resource persons. Then I said, oh, so then you must be a professor, engineer, scientist. He said, none of these. Then who are you? His answer was that I am a patentee. मेरे पास 2 patents है. I have acquired 2 patents. Then I said, you are not a scientist, you are not an engineer, but still you have 2 patents. I am very happy. For what? He says, I have been working for Mahindra and Mahindra plant in Nasik. And, for the last 13 years, as a semi-skilled worker, I developed certain fuel filters to increase the mileage. To increase the mileage, the, filters were created by him. And the net result is that, in fact, he got 2 patents. Then lastly, I asked, what are your qualifications, sir? He said, 8th fail. That humbled me because even today, many of the students also may be under the impression that intellectual property is created only by the so-called intellectuals who claim themselves to be the intellectuals. Every human being is capable of creating intellectual property. Mother, for example, you see, the necessity is mother of all inventions. That's what they say. Same thing applies even in the context of intellectual property. This is one important aspect. And of course, the Western world may be thinking that we are trying to steal their knowledge, their innovations, their creations. But we also have a charge against the Western world. They are also indulging in some kind of, in fact, the biopiracy attempts to do something else. Whatever may be the case, this is one important aspect as far as the biopiracy is concerned. But what we need to, biopiracy means what? Take for instance, 20 years back, when everyone started talking about intellectual property rights, they used to say Basmati patent. Why? Some company in Texas wanted to patent our Basmati variety with a little change as Texmati or, rice mati, etc. We objected and we won. Then somebody wanted to patent the, the antiseptic characteristics of turmeric in Mississippi Medical School in 1995. Again, we stopped saying that, sir, it is our traditional knowledge, there is nothing new. But today, we can say that our Ongol bull is going to be or it has already become a successful example of biopiracy. Brazil says that it is our bull, not yours. Why? Because maybe the sperm, etc., the DNA or germplasm, all those things were knocked away from India. Indian tarantula, like tiger spiders. There are so many. Even people try to claim that the butterflies in Darjeeling, West Bengal are belonging to some other country after taking these butterfly models. And we could proceed and prosecute the persons under the, in fact, Biodiversity Act. Neem, for example, there are patents relating to neem, more than 40 patents relating to neem in other parts of the world. Then biopiracy is taking place, and that is a charge of countries like African countries and Asian countries. The Western world is trying to copy from us. On the other hand, they are trying to say that we are copying from them. These are geopolitics. I don't want to go into, other issues. And many new developments are taking place, friends. Just I'll take last 5 minutes. I know that it's 11:33. Just 5 minutes. Human beings can claim intellectual property. Can animals claim intellectual property in their creations? Animals are also very innovative. You must have seen. Animals are also quite innovative. In South Africa, a pig started painting beautiful paintings, and the owner of the pig named it Picasso, not Picasso, Picasso. You can see the photo in Google, you will find out. And the paintings were very popular. Even Swiss Airlines copied these, purchased these paintings at 400 Swiss francs or 600 Swiss francs. Question is, who is the owner of intellectual property? Can the pig own copyright in the paintings made by it? Because the owner is saying, I'm giving everything. I feed it, I give it water, then it goes on painting. I supply the brush, color, and all. This is one aspect. Similarly, you can take your selfie. Taking selfie is a very big, very interesting habit of many. If a monkey takes a selfie and that selfie becomes very popular, somebody purchases it by spending a lot of money. Who is the owner of copyright in it? That issue came up in Indonesia sometime in 2008. A wildlife photographer made his, in fact, photo camera available to the monkeys, which were watching it very closely when he was using the camera. When he went away, they took a camera and took a selfie. That was published in some of the popular magazines. Then the question is, who will have the copyright? Ultimately, the matter went to the court. They said that no, monkey, pig, etc. cannot have copyright. Artificial intelligence also, dear students. Long time back, in Deep Blue was one of the machines, computer-driven, robotic-driven machines, which defeated Gary Kasparov in a chess match. And that was driven by artificial intelligence. Can you say that artificial intelligence can be the owner of intellectual property? As of now, there is nothing like it. I'll give you another very interesting example. With this, I'll close. You must have watched a movie, Chintakindi Mallesham, in recent years. It's all about intellectual property. Forget about cinema, songs and all. Who is this Chintakindi Mallesham? A gentleman from maybe Nalgonda, Karimnagar district. Then what did he do? He found that many of the weavers, చేనేత కార్మికులు ఉంటారు, వాళ్ళు when they use their hand, చేతితో నేసేప్పుడు ఏం చేస్తూ ఉంటారు, they move their hand front and back, top and bottom thousands of times. మనం ఎక్సర్సైజ్ చేయడానికి ఒక 2 సార్లు 3 సార్లు చైన్ పైకి లేపి కిందికి దించితేనే చాలా ఇబ్బంది అవుతుంది. But these people have to move thousands of times. What will happen to their joints? చేతి జాయింట్స్ కి లేకపోతే ఈ కీళ్లకు ఏమవుతుంది? His mother was doing that work. He was, in fact, pained by the kind of inconvenience caused to his mother. ఆయన ఒక మెషిన్ ఇన్వెంట్ చేశాడు, చాలా కష్టం మీద 2-3 సార్లు ఫెయిల్ అయి చేశాడు. ఇట్ ఈస్ కాల్డ్ లక్ష్మీ ఆసు మెషిన్. సో పోచంపల్లి శారీస్ కెన్ బి ఓవెన్ బై యూజింగ్ దిస్ మెషిన్. ఇప్పుడు చెయ్యి బదులు మెషిన్ మూవ్ చేస్తూ ఉంటుంది అనమాట. ఓన్లీ ఆ మెషిన్ కంట్రోల్ చేసి సరిపోతుంది. He got it patented. He was given Padmashri Award. ఆయన పాలిటెక్నిక్ డ్రాప్ అవుట్ ఏదో ఉన్నాడు, పెద్ద చదువుకోలేదు, బట్ he came out with one of the best rural inventions. So what I'm trying to say is that intellectual property can change the way the country is prospering. That is the reason why the present government, I'm not talking politics, our policy talks about creative India. Innovative India, Srujanatmak Bharat, Rachanatmak Bharat, Make in India. Ivanni, all of them will be possible only if the realization comes within the students, right from the, maybe school level onwards, about the importance of intellectual property, because it will find solutions to the problems, not to make the people rich. That is not the only objective, because the technology comes into the public domain. చిన్న ఎగ్జాంపుల్, ఒక క్యాన్సర్ డ్రగ్ ఇది బేయర్ కంపెనీ వాళ్ళు పేటెంట్ చేసింది. ఇట్ వాస్ కాస్టింగ్ అరౌండ్ 3 lakh rupees పర్ పేషెంట్ పర్ మంత్. ఎవరు కొంటాడు? 3 లక్షల రూపాయలు మంత్ ఖర్చు పెడితే ఎంతమంది ఖర్చు పెడతారు? దెన్ నాట్కో ఫార్మాస్యూటికల్స్, మన నన్నపనేని వాళ్ళు ఉంటారు, రాజ్ కుమార్ గారు అనుకుంటా, కానీ ఇంకా వేరే వాళ్ళ ఫ్యామిలీ ఏదో నన్నపనేని ఫ్యామిలీ. ఇన్ఫాక్ట్ ఇట్ రన్స్ ఏ హ్యూజ్లీ సక్సెస్ఫుల్ ఫార్మాస్యూటికల్ కంపెనీ కాల్డ్ నాట్కో ఫార్మా. వాళ్ళు అడిగారు, మాకు లైసెన్స్ ఇవ్వండి, మేము 8,000 రూపీస్కు మీకు తయారు చేసి ఇస్తాం, మాకు కొంత లైసెన్సింగ్ ఫీ మీకు ఇస్తాము, మేము 8,000 రూపీస్కి అమ్మేస్తాము, అందరికీ యూస్ఫుల్ ఉంటుంది. బేయర్ కంపెనీ రిఫ్యూస్డ్. ఆ పేటెంట్స్ యాక్ట్లో ఒక ప్రావిజన్ ఉంది, ఏంటంటే వాళ్ళు అన్రీజనబుల్ గా ఇది చేస్తూ ఉంటే, దెన్ వెన్ ది ద ప్రైస్ ఈజ్ అన్రీజనబుల్లీ హై, దెన్ కంపల్సరీ లైసెన్స్ ఇవ్వచ్చు అని చెప్పి. ఒక ఇండియాలో ఇంతవరకు ఒకే ఒక కంపల్సరీ లైసెన్స్ ఇచ్చారు నాట్కో ఫార్మాస్యూటికల్స్ వాళ్ళకి. ఈ రోజు 8,000 రూపీస్ పర్ పేషెంట్ పర్ మంత్, ఇంకా దానికన్నా తక్కువకే అమ్ముతా ఉన్నారు వాళ్ళు. హూ ఇస్ ద బెనిఫిషియరీ? ఒక సైడ్ ఇంటెలెక్చువల్ ప్రాపర్టీ ఉంది, కాదనని నేను. At the same time, the common man is the beneficiary. What I am trying to say is that intellectual property not only makes the people rich, but it also helps the public in resolving many issues. This is one. Eroju computer programs also, they are patentable, and the Delhi High Court has given a judgment last year, Ferry Dalani case and Jeffy. So if there is a hardware and software component, both of them together, then there can be, in fact, patenting of even computer programs. Otherwise, they are copyrightable. But trend is changing slowly and gradually, right? This is one important aspect. You will find intellectual property everywhere in our day-to-day life to corporate wars. And that is the precise reason why even universities also have their own policies regarding intellectual property. You can claim intellectual property in your literary works, in your articles, your monographs, your research papers. Only thing is, you must make it as original as possible. Copying is not permitted. So, as I already said, Sam Pitroda remarked that educational efforts on intellectual property rights must go beyond the IP offices, patent office, trademark office kaadu, and reach out to scientists and engineers working in national research institutions, universities, industry, the bar and advocates, as well as to the researchers and students, not just in metropolitan areas, but also in the smaller towns and rural areas of the country. I'm very happy that Sri Dasari Narayan Rao Government Degree College for Women has taken a very good initiative in organizing this one-day webinar rather, and to sensitize the students about the importance of intellectual property rights. Because there are two things. We have to protect the intellectual property rights, but at the same time, first we need to demystify the intellectual property rights. Idemi Brahma Padartham kaadu. What is intellectual property rights must be understood. We have to understand them, then create, then register, then protect. ఇవన్నీ చేయకుండా ముందే ప్రొటెక్ట్ చేస్తామంటే ప్రొటెక్ట్ చేయడానికి ఇంటెలెక్చువల్ ప్రాపర్టీ ఉండాలి. The capability of the human beings must be used to that extent. So I once again thank the organizers for giving me this wonderful opportunity, and I express regrets for keeping the other two resource persons waiting, and I only hope that the students got at least some fodder for thought in the direction of disseminating the intellectual property culture in educational institutions, even in certain corners of the country. Thank you very much. I'll stop here.
Thank you very much, sir. your thought-provoking address, particularly on very important aspects like patent rights, your live examples like animals and also artificial intelligence. They are really an excellent examples and also live examples so that everybody, even a common man, can understand what is intellectual property or what are the property rights and what are the patents or copyrights and so on. In fact, we are lucky enough to have Professor Reddy Garu for his wonderful keynote address. Sir, we look forward for your guidance, for your thought-provoking addresses in future. Thank you very much, sir. In fact, I remember one thing, particularly in case of turmeric. ఈ టర్మరిక్ విషయంలో మనకి అమెరికా వాళ్ళకి అనుకుంటాను కొంత డిస్కషన్ కూడా జరిగింది. టర్మరిక్ మాది అంటే మాది అని. వాళ్ళు ఎప్పుడు మన వాళ్ళు వీఆర్ ఫ్రమ్ సెంచరీస్ టుగెదర్ వీఆర్ హ్యావింగ్ దిస్ టర్మరిక్. ఇట్ ఈస్ పర్టికులర్లీ ది ఇండియా హూ ఇన్వెంటెడ్ ది టర్మరిక్ అని చెప్పిన సంగతి కొంత గుర్తుంది నాకు. కాబట్టి ఆ టర్మరిక్ ఎంత ఇంపార్టెంటో ఈవేళ ఇటువంటి ఇంపార్టెంట్ డిస్కషన్స్ ద్వారా కానీ ఒకవేళ దీన్ని నిజంగా ఎన్ని రకాలుగా ఉపయోగిస్తున్నారనే దాన్ని కూడా ఇట్స్ రియల్లీ గ్రేట్. ఒక అడవిలో నివసించేటువంటి ఒక మనిషి తనకున్నటువంటి పరిజ్ఞానంతో తయారు చేసినటువంటి ఒక వస్తువుని ఈవేళ పేటెంట్ చేయగలిగితే, ఇంటలెక్చువల్ ప్రాపర్టీ రైట్స్ దాన్ని ఇచ్చేయగలిగితే కామన్ మ్యాన్ సార్ చెప్పినట్లు ఇట్స్ రియల్లీ గ్రేట్ బెనిఫిట్ అందరికీ కూడా. చేనేత యంత్రాన్ని తయారు చేసినటువంటి ఆయన విషయం కానీ అట్లాగే ఇన్ వేరియస్ ఆస్పెక్ట్స్ ఈవేళ ఇన్ మెనీ ఇంజనీరింగ్ కాలేజెస్ స్టూడెంట్స్ ఆర్ ప్రిపేరింగ్ ఆర్ దే ఆర్ మేకింగ్ వేరియస్ మెషిన్స్. ఎటువంటి ఇది లేకుండా వాళ్ళు కూడా పెద్ద పెద్ద ఫ్యాక్టరీస్ లో కాకుండా దే ఆర్ ఆల్సో మేకింగ్ అండర్ వేరియస్ ఇన్వెన్షన్స్ లైక్ లైట్ హెలికాప్టర్స్. అటువంటివి కూడా కొన్ని ఇంజనీరింగ్ కాలేజెస్ లో తయారు చేస్తా ఉన్నారు. రూరల్ రిమోట్ ఏరియాస్ లో కూడా ది స్టూడెంట్స్ ఆఫ్ ఐ థింక్ ఎస్టర్డే ఐ హ్యాడ్ వన్ గురుకుల పాఠశాల స్టూడెంట్స్. they prepared a project from Andhra Pradesh. It got first in Andhra Pradesh and stood in 10th place in all India level. Atla remarkable achievements cheyadaniki in avakashalu unnai. So really once again I am thankful to Professor Reddy Garu and also the introducer of Professor Reddy Garu, Professor B.Balaswamy Garu. Now may I request Srimati Amita to introduce another legendary personality who is none other than a women champion and also a legal legendary Professor V.Vijayalakshmi Garu from Andhra University. I request Srimati Amita of Commerce Department to introduce Professor V.Vijayalakshmi Garu.
Good morning to one and all, and welcome to all today's Sunday National Webinar on Intellectual Property Rights. It is a great privilege to me to introduce today's one of the resource person, Professor B.Vijayalakshmi Madam Garu, Professor in Dr.B.R.Ambedkar College of Law, Andhra University, Visakhapatnam. She did his MSc ML in Business Laws and PhD in Intellectual Property Rights and Copyright Laws and qualified UGC NET. Her teaching experience is 26 years, and academic experience is teaching for more than 26 years in University of College. And Madam is also awarded the Perry Narayan Gold Medal Award for Best Thesis for the year 2008-9 of Andhra University. Ma'am's administrative experience is Chairman of Board of Studies in Law, Assistant Principal, Warden in Ladies Hostel. And also she is member in BOS, DRC, DC of Andhra University Law College, and also director of Alluri Sitaramaraju Center for Tribal Studies, Andhra University, and also convener in Andhra University Women Grievance and Redressal Cell. Also NAC member in the period of 2013 to 16 and 2019, and also NAC assessor from 2019. LASEC member in 2017 and 18. Ma'am published papers in 28 and presented national and international seminars, conferences above 60. And she is author of the book on arbitration. Under the ma'am guidance, 9 PhDs are awarded, 3 are submitted. Under the guidance is 16. LLM guidance 70, LLM project 750. Subject teaching in different papers, including intellectual property laws, corporate finance, law of insurance, civil procedure code, company law, contracts. She delivered guest lectures at Andhra Pradesh Law University, Geetham University, Andhra University MBA workshop and seminar conference participation and special lectures as resource international and national research about 70. Thank you, madam. Thank you for giving this my opportunity. Thank you, sir.
Thank you very much, Amita.
Thank you, sir.
We are really lucky enough to have the variety of people or legendary personalities, particularly in the specialized areas. First of all, I thought, can we get the people from various aspects to deliver various lectures? Now, after getting Professor Vijayalakshmi Garu, Professor Reddy Garu and B.Balaswamy Garu, I feel very happy to have such a great people on this virtual platform. Thank you very much, madam, for your ready acceptance of delivering your address to our webinar. I should also thank Professor Sita Garu, who introduced madam. She said madam would be more of expertise more than me, and I request her. So she also guided me to talk to madam. So I am also thankful to Madam Sita Garu for introducing Madam Vijayalakshmi Garu. So with these few words, may I request Professor Vijayalakshmi Madam from Andhra University to address our webinar.
Good morning to all of you. Good morning, Sri M.M. Nayak Garu, Commissioner of Collegiate Education, Dr. Nangmani Garu, Chief Patron Principal of the Women Degree College, and Dr. P. Sai Babu, HOD Political Science, and Mrs. S. Lakshmi Kantam, HOD Commerce, who is the coordinator, and also P.L. Subramaniam, who is the technical advisor, student friends, other invitees. Very pleasant good morning, and in fact, we are reaching towards the good afternoon also. So, after listening to my, and of course, good morning to my co-speaker, Professor G.B.Reddy Garu also. And after listening to G.B.Reddy garu, who has given a bird's eye view just on the IPRs. Intellectual property, which we shortly call as the IPR, is itself is an ocean. It is not just one paper or something, a limited subject matter. Itself consists of many areas, and each area is having a vast subject matter to be explored, studied, and learned. This subject, which is not of very old, I mean, say it is not ancient and all, it is originated with the Industrial Revolution. And then, so far, the intellectual property teaching, learning, and all these are there. They have commenced only in 95, 90. Of course, this subject was there in few universities of our country, like Delhi University or National School of Bangalore. And it is only after the 90s, this subject has got a lot of significance and attention of all the universities and industries and all. And then the subject is being introduced in the university curriculum as a, some universities introduced it as a compulsory subject, some have introduced it as an optional subject. And apart from having this subject under the law curriculum, this subject is also having is being taught in the other like commerce, economics, and management courses, different other, and even nowadays the engineering syllabus. So engineering courses, they are also including this syllabus, because recently I visited the engineering college of AU, and they have in fact got a IPR chair, and because of the significance of this subject, right? So before I begin my address, I would first of all like to ask what our intellectual property is. How many of we understand what an intellectual property is? I would like to start from the very basic step one, and I'll give you a very basics of what IPRs are. Because the area is being touched and been touched upon by Professor Reddy garu. First of all, what an intellectual property is. Traditionally, if we look into, we understand that property means there are only two kinds of properties. That is the movable properties and immovable properties. Movable properties means goods that we understand, and immovable properties that are lands, buildings, etc. So how come that this third property, that is the intellectual property, has come up? Where this property is? How can it be owned? How can it be protected? What are the various forms of this property? So this is a base, and then what is the significance of this property? Does it carry any significance? This is I'm going to highlight in my address. So first of all, let us see what are the different kinds of property, and the third kind, we have also read another categorization of the property, that is a tangible property and intangible property. So under the intangible property, many of us, we have also read about the goodwill. Goodwill, which we generally read with the business transfer of the business property, etc. So along that, that property will be having a goodwill, and that goodwill can also be sold or transferred and all. Mostly the commerce students and all, they have learned all these things, and many law students also, they know about these things. So intellectual property, first of all, when we say, there are two terms in this, one is the intellect and the other is the property. So first of all, why intellect? How can an intellect become a property? Before that, the question is an intellect a property? That is the major question. Is it intellectual property? If it is a property, where this property is, right? So to clarify that what intellect is and how intellect can be a property, we have a number of and innumerable number of goods around us. You can see just goods which are of costing. I'm having on my table a small pen is there. Perhaps this pen is of costing of 10 rupees, maybe. But this is a property. This is my property. This is a physical property. This is a mobile property. I'm the owner of this property. I have purchased this property. So, and if somebody has taken this property, suppose I have lost this, somebody has stolen this property. I have every right to file a case against a criminal complaint that there was a theft, somebody has stolen this property, right? So, a property of worth less than of 10 rupees, 5 rupees, 2 rupees, or even a needle, small needle, which may be say 1 rupee, that is a property. And if that is stolen, I have been given every right to take action against the whoever, the thief or whoever it is, the person who has taken it. And we have a, elaborate machinery to protect the rights of the owner, and all these things are there. Then think of the person who has created this pen, who has made this pen, out of whose intellect this product has come to the world. Is it not a valuable thing? Is it not the intellect of the person should be recognized and protected? This was the justification given in the early days, that is after the 14th and 15th centuries. Till then, it is not that the intellectual products were not created. Inventions and creations of the literature, everything was there, created. But the question of protection did not arise. Question of protecting the intellect of the person did not arise. And why it did not arise is that there was no trend of copying the things. There was no thing of copying, mass copying, making multiple product reproduction of the things. Before 12th century and all, people, suppose a writer used to write and a copy is required. The writer has to sit again and write a second copy. There is no question of making multiple copies and selling them, marketing them and earning so much. So with the Industrial Revolution, when the Industrial Revolution has started, so very first impact of the Industrial Revolution was the mass production. Of course, with the mass production, the market has increased, it has grown up, people have started purchasing, and the product has ramified from one place to the different places and all. But it so happened that the person who has created, we call the intellectual creators, we name them, right? Not the intellectual workers, we call them, not the manual workers. We are the persons who create something, who makes the new, invent something. They are called intellectual creators, right? So the person who has created this intellectual product, he was not receiving any benefit for his hard work, his intellect, his knowledge, basing upon which all these are created. A third person used to exploit these things and he was enjoying all the profits therein. So that's how the question of having their rights protected has come up. And these intellectuals, whether they are the authors, that is who are writing books, literature, etc., or composing music, or inventors who are inventing new things every day, one day or the other. So these have made the representations to the crown. Now, remember, this concept of intellectual property is having a European origin. So basically, this has commenced in UK, Spain, France, Germany, Italy. These are the countries where this concept has developed, originated, and further it is being developed, and it is slowly being taken out into the other parts of the world. So in the beginning, when there is guilds or associations of the authors and inventors, they represented their case to the crown that we are the hard workers, we are the actually the persons, creators, and we are not being given our due recognition, and our rights are not protected, our things are not, some third person is enjoying all these things. So then for the first time, the issue has come that, okay, if that is the case, how they are to be protected? First of all, for protecting anything, the very first thing that is to be decided it is what it is. I want a protection for something. So the question is, what is that something? Is it a pen, pencil, book, a dress, gold, jewelry, house, building, shop? What it is? So that is to be decided first. So then said that this is something which I have written. This is something which I have invented. So invented, when you have invented, yes, you have invented this pen. So pen is protected because pen is a property. But this is a physical property. What about my intellect? The intellect which I have spent, I have used it. Then the question said that, okay, if your intellect is to be protected, sure, how can it be protected? Then it says that then it has been decided that intellect should be treated as a property. Then only it can get the protection, all the protection that a property is enjoying, regular property is enjoying. So then a very next question, how can it be a property? So the question is, yes, it can be answered by looking to the characteristics of the property. What are the characteristics of the property? Yeah, it is have a title, it can be enjoyed, it can be owned, it can be sold, it can be gifted away, it can be thrown, it can be relinquished, right? It can be licensed. All these are the characteristics of the property. Well, property, what you can do with your property. Now, can all these things be done with your intellect? Tell me, can it be done? Is your intellect is yours? Yes. Can you share your intellect and knowledge with any other? Yes. Can you gift it away? Yes. Can you use it? Yes. Can you, if you want, you don't want to use? Yes. So it is having all the characteristics. So therefore, it has been decided that yes, when this intellect is sharing, it is having all the characteristic features of a traditional property. Therefore, the intellectual intellect is also a property. But then why? How? Where is it? So there it is in there, your brain. It is within the brain, it is. Your knowledge, your ideas, everything is in the brain. And for that ideas, knowledge, when they come up in a physical form, then they acquire a physical, whatever it is. Say book, a textbook is there. We purchase the textbook not because of the physical book. Physical book, suppose whatever it is, I'm having on my table, a book is there, on the transfer property book is there. So that book costing 500 rupees. But if I go to just a book is a physical material, if I want to sell it, say I'll go to a book paper shop and say I want to sell. He may give, madam, this is 1 kg, I'll give you 5 rupees. So the cost of the material is 5 rupees or 10 rupees. But we are buying for 500 rupees. So what for you are paying 500 rupees? That you are paying for the content. The content which consists of the book. And that content is what? The intellectual knowledge of a person. For that which we are paying. A CD, a compact disc, cost of that maybe we are say is a movie CD, and maybe a 200 or 300. But the actual physical cost may be 10 rupees. But why you are paying 200 rupees? Because of the content, which is again an IP. So here there is a no, yes, it is a property. Therefore, it has been recognized, intellect is being said that yes, intellect is a property, and then onwards, intellectual property. In the beginnings, this phraseology was not there, nomenclature was not there, that this is a copyright, this is a patent, not like this or there. If authors have written, say authors right. If inventor, inventors rights. So this is how it has started all the beginning like that, right? So then what is the difference? What is the difference between this and that? This property, IP, intellectual property, and the traditional property. One major difference is that intellectual property is intangible. You cannot see it. It is purely there in your brain. You can see it in the form when it is manifested through some product. Maybe it is a new car, maybe your computer software, maybe your cell phone, maybe a new book, whatever it is written, you have written. So that when it takes that form, you can see that yes, physical form, isn't it? So there your intellect, your knowledge is being expressed in that way. So then we say that yes, this is the intellectual property. So now coming to when we say that intellectual property, so the property itself is a very broad, subject matter of this property is a very broad, and for convenience, sake of convenience, we have divided this intellectual property rights under two categories. And there, under the first category is the industrial property, and the second one we call it as the copyrights, right? So in other words, we say that inventions and expressions, that is the dichotomy of idea and expressions. Inventions basically are created based on the ideas that we have in our mind. Where whatever the ideas ideas are the precursors of inventions. First, ideas will come. That idea is to be materialized, it's to be worked out in the form of an invention, and then that invention again is to be physically worked out so that a physical product basing on the invention can be made. So that is where the ideas from idea to a product transfers from there to there. Similarly, the another way through which we use our brain is by making expressions. We express ourselves in different ways. There are different ways of expressions. And for all the expression, it is our intellect we use it. Just small example I'll give you. I just want a glass of water. I can simply say, come on, give me a glass of water. I can say, I can draw it and show you and say. I can sing and tell you. I can draw a painting and tell you. So there are ways, different ways of expressions, making expressions, expressive field, right? So expressions may be in the form of writings, in maybe paintings, maybe drawings, maybe sculptures, right? And then even the cinemas which we watch, we are very fond of watching the movies and all cinemas. So these are all, and the music which listen always, no? So they are all expression. We express ourselves in a particular way. So what is the source of all the expression? It is our brain. Are understanding? This is our brain which is the source. So therefore, whatever we use, basically our brain works either in generating new ideas or expressing ourselves. And basing on this only, the intellectual property is being categorized broadly into two. One is the industrial property, another is the copyrights. Industrial property again consists of inventions, designs of a product, and trademarks. These are the traditional ways, traditional IPs. And then the second one is the expressions. All the expressions, they are protected through laws of copyrights. So industrial property, why we call it means inventions, whatever the inventions you are making, they are eligible for a protection. And that field of protection, the laws that protect the inventions, we call it a patent. Okay. So patent means the legal regime, the law that protects inventions. Understand? Another area of industrial property is the design. See, why we call industrial property? It is not industrial laws. Don't get confused with. Industrial laws are different. Labor laws and all those things will come. This is industrial property. Basing on the inventions, industries are set up. No. Inventions, they are to be materialized, and finally by using, any entrepreneur may come up and say that we want to use your, exploit your invention by having at the last cell manufacturing level and all, right? And for that purpose, what is the first step? Idea, invention, that's to be materialized. And when it is to be materialized, very first thing comes that how does it look like? It looks, how it will look like? Suppose a person has invented, say, a new type of car, a very small car or something, having, it can fly, it can go in the water, it can be folded into a small thing, something he has invented like that. It's a new thing, totally new in the world. Okay, ideas have come, everything is there. But when it has to take a physical form, no, how it will look like? Would it be a big? Would it be a small? Would it be something this way, that way? Would it be having a lid, this, that? How? How would it look like? For that purpose, designs are required. The product, each product should have a design, isn't it? And without design, you cannot. So what that design will be? How it will look like when the product will be thrown open to the public? So designs, they are very important for the trade or commerce of the product, success of the product. People will buy a product looking at the design also. First, in fact, that is the first thing that people will take a decision, isn't it? They'll say that how it look like, let me see. So that is, and then a design, creation of a design is purely intellectual knowledge. We have to use our brain. A lot of intellect has to be placed therein to see that the design that is a very attractive, that will catch the market, that will serve the interest and taste of the consumers. So these are the things. So therefore, design is required. So ideas, this, that, the design, the product is ready. Now the next question is marketing, because the product when you make, you don't keep it in your house or you keep it in the laboratory. Right? So they have to be marketed. So when they are to be marketed, then the very next question is, by what name you are going to market it? There should be some kind, no, some name, something is to be given to it, some identity. Otherwise, how the people will identify, how the people will remember this? So you have to give some name. Is a new, say take for instance, a Maruti car is there. Maruti car is car. But there are so many models are there, no? Maruti, this one, there, Ciaz is there, Alto is there, this is there, that. And look at each model you look, there is a difference. So when you go to the car shop, the very first question he will ask that, sir, which car would you like to take? So are you saying that some car I will take? There you say that I want this particular model. So that name, that trade, that mark is being attached to that. So that will make. So when we talk about that wrist, say watches are there, so many watches are there in the market. But then, if suppose there is no mark, no nothing is there, all the markers watches are looking alike, how would you identify? How will you choose? How will you select? And then how will you tell to your friends? No. Oh, suppose your friend has seen a wristwatch in your hand without any identity, without any mark. Then she will say, oh, it is so nice, so nice. Where can you purchase this watch? You say that I have purchased from so and so. So she will also go to the shop and she will say that I want a watch. The very first question the shopkeeper will say, which watch, ma'am? He'll say, oh, some watch. Yesterday, my friend came to your shop. She has purchased that watch I need. Oh, very difficult to say, ma'am. There are so many watches are there, which watch and all those things. Isn't it? But now suppose you went to shop, you saw, yeah, this is a Titan and the Raga variety. Then you could say, I want a Titan and the Raga and so and so. So, okay, madam, now come on, this is the thing. So that is the mark, which gives an identity to the product. No, commercial, it has totally commercial significance. So therefore we include these three under the industrial property. And coming to your expressive field, which we express, whatever it is, the literature, drawings, paintings, music, and all those things. They are even the cinemas and all the architectural works. So they are all expressive field, and they are protected through the laws which we call as law of copyrights, right? So the copyrights protects expressions and patent protects inventions. Those are the basic things. That is, there is a lot of things are there to be told and all, but basically these are the things that is, okay. Now, the next one is how to protect the copyrights and what is the copyright, limited minimum things, what should be there for a copyright. Now, for the copyright, things are that anything which is an original. Suppose you want to have a copyright for your works. The two principles which the copyright guides is, one is that it should not be stolen. Thou shalt not steal. That means it should be original. And original, it does not mean that first time it should come. Original here means you should have written it. It should have come from your mind, your brain. You have used your intellect to produce that. You have not copied from anywhere. Okay? And once by using your intellect, when you produce something, you have written something, you enjoy a right to make the copy of it. Only you enjoy the copy, right? So that is actually the meaning. Copyright, as the registrar, or generally we all say that not a right to copy. But yes, in other ways it is a right to copy. But that right belongs only to the author, not to the third person, right? The author is being given to prevent all the others not to make copy. It's a negative right. You cannot, if you have written, you can prevent, you can stop all the other person from making the copy of the work. So this is the thing, that copyright. And a copyright is not, once you have created your work, you enjoy, number of rights are attached with this copyright. Not just making a copy of that, whatever you have. Suppose you have written a story. It is not that only you can write and make a copy. There are other rights are associated with this. You can make a copy of this. You can perform that. You can communicate it. You can record it, recite and record it. And suppose a film producer approaches you and saying that a story is a very beautiful, I want to make a film over it. Yes, you have a right to, because you have, first right is yours, author's right to make a film. So he can give the right to other person. So you have a right to make film. You have written some poem. So it wants, somebody comes that I want to make a song over it. So music rights. So all these kinds of rights that are being associated with the copyright laws that is being given to the authors. And authors does not mean only the person who writes, okay? It may be the person who writes. In case of music, it is a composer. In case of the films, it is the producer of the film. And in case of the artistic works means paintings, drawings, sculptures, etc. In that case, it is the artist, we call them, right? Don't get confused with the artist, mean generally film artists, okay? So these are the things. So only thing is that it should be original. You should not have been copied and all. And it's a very vast, very broad, subject matter, and the scope of it is also very broad to be explained each and everything. For the time being, you understand that anything that two things I'll make you clear here. One thing is that it need not be, what you're writing, it need not be, say, very quality oriented. You will enjoy copyright only when you have written, say, a work which is eligible for Gyanpeeth Award, National Award, this, that, nothing. Anything you write, if it is original, it has come up, you are entitled for the copyrights. First thing you remember. Second thing, how much it should be. How much it should be means, it's not that only when you write volumes, 10 pages, 20 pages, 100, 500, nothing. Even one sentence or few words, if you have written, that you are entitled for a copyright. So two things. Copyrights are not, there's irrelevant they are. Quality and quantity both are irrelevant for copyrights. Only thing is originality, and originality means it should have come up from your brain. You have created it. The moment the work is created, it is protected. Registration of copyright is not mandatory. Again, another point which you have to learn here. Right? Now, the second thing which I'm going to tell you is the patents or the inventions. So when you say that inventions, what is an invention? So everybody of us understand that invention means anything which is a new and which has come up in the world for the first time, right? So again, we say that yes, there is a, it should not be copied from any fee, what do you say, from any other inventions. That means new, it may be a new thing or new process. Anything you have created, anything, both of them. You may make a new product or you may make a new process. Take for instance, you may invent something which is a new product. Say a medicine is there, right? A tablet is there which will cure your fever, headache, and something, 3 or 4 things, new thing. Earlier, such kind of was not there. Or say you have invented a drug which will only single dose is enough, a diabetic drug, right? Once in a month instead of taking daily, once you have taken. So there, what happened? Product. When ultimately when you made that product, that is a product. For that you enjoy. Then process also. Suppose how it is to be treated. What is the process for getting that product? So even that is also protected. Because sometimes the process may be different. Same product may be you made by using a different process. Understand? XYZ is equal to A. Right? So that A can also be made by using some ABCD or a LN, something like that. So the process won't change. So if it is a new process, for the process again, the inventor gets a patent. For the ultimate product, again, you will enjoy a patent for that. So this is to be understood. Only thing is that what is saying that it should be 3 things. We call it as for having a patent protection. 3 preconditions are required. 3. 1, novelty. Novelty means it should be new, absolutely new. It should not have been copied. It should not be existing in the world, nothing like that. Novelty concept, we say. Now, the next one is the utility. It should have also utility, usefulness. Of course, this is not being given under the Act, Patent Act, but indirectly it is been in another provision. So that is there, right? So it may be new process or product having industrial application and inventive step. These are the 3. Inventive step must be there. Inventive step means a step which distinguishes this from the, nobody could have found out. You have found out, right? Everybody wants to, everybody can make tea. Nagmani madam can make tea. Rudra can make tea. No? Madam, I think you can make tea. I also can make tea, right? But then suppose someone has made a tea of such a type that none of us could make. None of us know. In fact, we don't know how this tea has come up. After drinking for 10 cups also, we could not know, God knows, how this tea is made. We added this one, that one, this one. No, it did not come up. That is the inventive step. You know, that is the thing which you have invented. That is your effort. That is your intellect. That is what required. Otherwise, everything bulb is made. So, what is there? Any electric person who is having a knowledge in that he can make. But if suppose it is made in by something new which nobody could make, that is the novelty. That is the inventive step. And that is absolute requirement, second requirement. And third one is the industrial applications. Industrial application must be there. That means whatever you are inventing, it's capable, it should be capable of what? Having a mass production industrially. Sometimes it may so happen that it will work out in the laboratories, very good and fine. But when the same thing is being tried at the industrial, it fails. So no, not that. Okay, that is not expected. So all these are called preconditions for that. Okay, and then there is a difference between copyrights and the patents. Patent protection that protects the invention, registration is mandatory. Without registration, you cannot have a patent protection. Okay, so you may say that why should I register and all? Okay, well and fine. Don't get it registered. Nobody will take away. But then suppose your invention is being copied, is been exploited by a third person, you will not have any remedy. Remember, no remedy. So invention with patent or without patent, you can enjoy your inventions. But in case of its violations, infringement of patent rights, only those inventors will get protection whose inventions are patented. Right? So it is a protection is statutory. Patent Act is there. And according to the Act, he is entitled for the protection. So very question when comes that my invention is copied, I want the very question is that, okay, your invention is copied. First of all, prove that your invention is an invention. Then prove that you have a registered your patents, because your protection is depends upon the provisions of the Act. Act has given the patent holder these rights. These rights are subject to the condition that you have patented as per the provisions of the Act. So therefore, that is the difference. In either case, it may be copied. Without patent, also your invention may be copied. With patent, also your invention may be copied. But then, if you have taken a patent, you have a remedy. You have a recourse, legal recourse to take action against the other person. Right? Understood or not? This is the minimum patents and the these are the IPs. Why registration is necessary and all those things. Then coming to invent designs and patents. Of course, patents are protected for only 20 years, and then copyrights, they are protected for the author of the life and 60 years thereof in India. Okay. Then designs. So designs also, they are another feature of the intellectual property, and designs which are looks alike aesthetic features. Designs, they speak about the aesthetic or looks of which attracts. Very first thing, the moment you look into, it attracts you, and that's why you go. That's why you go for that. And whether it is a costly thing or sometimes it so happens that even a very, very cheap thing, very, say, low cost product, it may attract you. You don't look. And sometimes it's a very costly attract, yet you feel that you don't feel that buying that because it does not look nice. Later on, other things will come up, whether it is strong or not, whether it is durable or not, whether it is what is the quality, and all things will come later on. But first is the looks. The moment you look, it has attracted you. No. So that's the role, that's the significant customer attraction role it plays designs. and which is again an intellectual property. They are again protected. There is a Designs Act is there, and then the designs are protected for 5 years plus 5 more years, that is the 10 years, that we know. Then the trademarks area. So when we said that what is a trademark means a mark which is attached to a product or service also. Trade, see the word, two words consists of trade and mark. So trading, for the trading purpose, once the product is made, it will be traded. And that product, when it is to be traded, some mark is to be attached, fixed to it. So this trademark area has been broadened. Earlier, it was thought that trademarks are to be attached only with regard to the product, physical products. But then, no, there is a trade and service also. Trade and service is there or no? What is a service? A banking service, education service, entertainment service, communication service, construction service, insurance service. They're all services. And all these services are having, they trade, isn't it? You have joined in the college. What kind of service your college is extended? It is a service, isn't it? But then that, how you know, but these services can also use a service mark, which is a trademark again. Okay, for instance, very most common, which I'll say, State Bank of India, right? Right in front of our college, it is there. So trademark, what is the State Bank do? A service, banking service. Can you identify without State Bank the words? Is there any symbol used by there? Yes, the keyhole. By looking at a distance, you say that, oh, there is a State Bank. Right? Life insurance, insurance services. No, without reading all the words, Life Insurance Corporation of India, this, that lamp and that two hands. Oh, this is a life insurance. And I think your college might be also having a logo therein with a lotus, with a rising sun, and again something small, very small. Maybe your principal, maybe madam will be able to tell exactly what it is. So that is, of course, trademark and the logo, there is a difference. Trademarks are used to commercial products, understand? For the marks or services, goods or services, it can be used. Whereas the logo is a philosophical thought. It represents was basically the institutions or the charitable institutions, they use that because they have some philosophy behind it. They want to do this, they want to achieve something like that. So trademarks, patents, designs, these are the traditional properties. Traditionally, that means for the first time, when the IPs have started protecting, then these are being introduced. But then nowadays, the scope of this IP has been broadened, and now we have the other things also been added up there. That is the geographical indications. And what is the geographical indications, and how is that IP is related to the geographical indications? So geographical indication means an indication given, similar to a trademark. Trademark is a mark given to the goods. So geographical indications are also marks which are given to a particular products, which are originate in a natural product or artificial product. But then those products are specific to that area. Okay. Your Banganpalli mangoes will grow only in the particular place of that. Will not go throughout India. Basmati rice, that grows only in the northern India and East Pakistan. Indo-Gangetic place, that's grow. It will not grow anywhere. Why? Why will not grow? People from the Srikakulam, they went to that Punjab and all, they brought the raw paddy and all, they sowed it. Plant has come up, it has grown, everything is there. But then it lost one thing. What is that? The aroma. No, the very thing for which we purchase the basmati rice. Very meaning, literary meaning of bas means aroma. That could not be. Why? Because that aroma and that texture, even that long grains also have come up. But that texture and that aroma it could not possess. And how is that it is missing means that aroma and that quality of the grain can be grown only when the grains are grown at that particular climate, particular soil, particular weather conditions, moisture level, temperature, only then that it grows. So therefore it is a specific to that. So they are geographically particular place, that's all. So they are the natural products. No, we have so many things. Similarly, it may be an artificial product also. Kandapalli Bamalu are there, Pochampalli sari is there. So they are what? They are being viewed by a particular community and only that community has the knowledge how to view that. And that knowledge passes from generation to generation. So they are to be protected. They are to be protected from misuse and abuse. If they are not protected, what will happen? These unscrupulous persons, they will grow something or they will make something and they will sell by saying that this is only Pochampalli sari, this is only Kanjivaram sari. Or say, okay, we'll buy. After using for one day, they will be tear off or the color will go off or something will happen. Then you feel that, what kind of sari this is? So there what happened? The original people, the original who have protected and continued the culture, their reputation is going to be marked. So in order to protect them, these GIs have come. So similarly, layout designs and all those things, whatever it is, computer software, entire computer software industry is dependent upon the copyright protection. Because the computer software which is written is been recognized as a literary work. After all, the writings, zeros, ones, symbols, codes, schemes, they all comes under the literature. Again, remember, literature does not mean only the writing of books, stories, this, that. Anything it is written. It may be alphabets, it may be numerals or new alphanumerical things, anything it may be. Codes, schemes, they are all entitled for copyright protection. Okay? So look at it. Similarly, entire film industry, it is based on its protection. Films which are made, entire film, there are different copyrights out there, right? So that is again the another aspect which you have to go through. And then briefly, I will tell about the economic significance, right? What is the use of this intellectual property? Does it carry any use or what is actually? So I would say that the country, the more rich in its IP, the more rich it is. Okay? Very simple equation. More IPs, more rich. Okay? Remember, look at the countries around the world. Small countries, Norway, Spain, Italy, UK, maybe equal to our one or two districts like that. They are. But they are all advanced countries. And we are developing countries. We are still developing. In spite of having 135 crores. We are big in number. Okay, we are big in number. So what is required is that knowledge sources to be improved. That is what required. Because of these inventions, basing on inventions, industries are set up. When industries are set up, employment is created. Then economic growth will take place. Basing on the economic growth, income will increase. Personal income, national income will increase. And then what will happen? What else it will become? Right? Living standards will improve. GDP will grow. Foreign reserves, when the same product, suppose it is a very good quality product, you can export the products, and by exporting you earn the foreign reserves. And when it is the earn of foreign reserves, revenue not only to the person but the government also earns. The more the manufacture, more the purchases, government earns the more revenue, taxes. And then international reputation also, isn't it? Oh, so and so country. See, one small thing you make, cell phone, Nokia phone from Norway, that country has become famous. The car, which car? That one, that is from Japan. This refrigerator, this is from Korea. See how reputation is earned by making a quality product and gaining or earning lot of reputation for the products. Not only your personal reputation, but also you fetch reputation for the country itself. International reputation, through which international trade increases. Come to copyright field, entire publishing industry. Our country is the 7th largest publishing industry in the world, you know. It depends upon the writings which are protected through the laws of the copyright. Film industry, which is responsible for creating jobs and etc., employment opportunities, so many. Music industry, software industry, arts, artistic feature, artistic works. There's a huge billions of dollars market is there for artistic works. So this is the significance, economic significance of intellectual properties. GIs, they themselves hold. Your products, when you export, when you sell it, people will come to know. Once upon a time, a Banginpalli mango means only we people used to know in Andhra. But now, the entire country knows it. It even is exported because of its quality, because of this. Oh, this is this. So that is the economic significance of the things. So the field has also increased, say, right from your basic patents or trademarks, and then geographical indications. They are the new things that are being added up. And then, what do you say, that layout designs, which we require, semiconductor chips. They are the hearts of any electronic gadget. No, it will not work unless you have small chip, right? Maybe a small watch or maybe electronic, what do you say, your heater or a washing machine or a TV or computer, whatever it is. All the electronic gadgets, they work on that small semiconductor chip. And that chip is the intellectual knowledge. If you open up, you will see how they are arranged, small integrated circuits. The circuits are important. They only make the instrument work. And that is purely intellectual property works. So that is again being recognized. And now the field is totally growing up, no? Biotechnology, that has been added up. Earlier, inventions means people used to think that inventions means only in the physics and chemistry, like that. But no, not like that. But now they said that no, inventions may be in any field. It may be a biotechnology, it may be a nanotechnology. Nanotechnology also you might have heard of. So even that is also entitled for your intellectual IP protection and all. Okay. And one more thing which I would like to add here is that intellectual property, which requires international protection. And it is which is very, very important. And the reason for this is that unlike the traditional property, you know, you have suppose a house or you have a book, they will remain with you. They will not go away anywhere. But suppose you have your knowledge, you have written or typed something in your system, it may reach to the other corner of the world with a click of button. Am I right or no? All the information, all the knowledge which you feed here, make here, it just may be copied and gone to the other, crossed the countries. So what is the protection? How you protect? Because your laws, whatever the laws, maybe a Patents Act, Trademarks Act, Copyright Act, GI Act, this Act, that Act, whatever the laws, they are called as territorial because they are applicable and enforceable only within the boundaries of your country, not beyond that. Why the other country will respect your laws? The moment you go and say, who are you? Why should I protect you? Our laws do not protect you. Our laws protect our people. Therefore, and this is not the problem with one country and one person. This happens in every country. Today, the authors of this country may feel that their works are copied by the, say, neighboring countries or US, Canada, any country. Tomorrow, it may happen that the authors of that country, their work is being violated here. They are being copied here. So, same situation. So, therefore, all the countries, they thought that this is something different. All the countries together, they come to an agreement that I will protect your works, you protect us. No, we had to take action against the intellectual thieves. We call it as intellectual thieves there. So therefore, international agreements are being convened in all fields. International agreements, which we call as conventions and treaties. So they are convened. So in the field of, say, patents or the industrial property, we have the Paris Convention and the Berne Convention for copyrights, Madrid Protocols for the trademarks, Hague for the designs, and then, and the most modern, we have the TRIPS, trade-related intellectual property aspects of WTO. So that has broadened and it has a comprehensive. It is a comprehensive, brought all the things together and at the maximum extent, it tried to include all types of protection at the same time, It has obliged all the countries, all, I think 169 countries are there. So all the 169 countries now are bound to follow. They have to. The impact of TRIPS is that all the member countries now are obliged to extend the protection to all the IPs of other countries. If you want protection in other countries, you too have to protect. That is the outcome of that. And this is absolutely required. Is it required or no? Isn't it? International protection is absolute requirement. So I think benefits which we are, what is the benefit of having IPs means, first of all, the very benefit is that encouragements, encouragement by rewarding and yeah, so that is there. And then significance, that is the extended to monetary significance or revenue significance to the country itself. That is again another benefit of IP. The knowledge is power, which we say, no? Knowledge is the power. So that is how the things with regard to the, and then the other things which if time is there, I will, but briefly, because my address, I wanted basically to make the students, because most of them are, I'm seeing the student community. So that is the degree holders and all. And that is the basics of IP, which is required to be understood by all of you. So I hope I have made a small attempt in this regard, and you understood, I think so. And if any further clarification, you can contact me. I'll clarify. And I thank the authorities for giving me a good opportunity to interact and express myself and share the platform. Thanks to all of you.
Sai Babu, sir, please unmute yourself. Okay, continue, sir.
Thank you very much, madam. Certainly, student through your guiding in trade related rights, copyrights, various trademarks, registration of patents and other aspects. And also, particularly, even a layman can understand through your lecture, like selecting various particular aspects like banking, state banks, Andhra Bank, or so on, and also cars, watches. These are really live examples where we can properly understand what is the intellectual property or property rights, various trademarks particularly. Thank you very much, madam, for your lively and also enriching lecture. Now, may I request Srimati Jerina Begum to introduce Professor Balaswamy Garu, who is another important professor in this. I request Srimati Jerina Begum to introduce Professor.
Thank you, sir. Thank you, sir. A very good morning to one and all. My name is Sheikh Zarina Degree College for Women, Palakolu. It is a great honor to be a part of this national webinar, and my privilege to introduce Professor B.Balaswamy Garu. He is an eminent educationist and well known for his simplicity and hard work. Garu is presently chairperson of Board of Studies in Communication and Journalism, Osmania University, Hyderabad. He also served as head of the Department of Communication and Journalism, Osmania University, Hyderabad. Before joining Osmania University, he served as reader and lecturer in the Department of Mass Communication, Assam University, Silchar. He did his MA and PhD in Communication from University of Hyderabad. He is author of the book of Communication for Sustainable Development. He teaches different papers including communication theory, electronic media, and development person for this national webinar. Now I am requesting Sai Babu sir for welcoming Balaswamy Garu to deliver his valuable speech. Thank you, sir.
Swami is
Garu to deliver.
Hello. Is it audible, please?
Yes, sir, you are audible.
Subramanian garu.
It is audible, sir. Please continue.
Okay.
Sir, please unmute yourself.
Okay.
Sai Babu, sir, please unmute yourself. Hello. Sai Babu, sir.
Sir, Subramanian Gar, am I audible?
You are audible, madam.
Okay, sir. Sir, let us invite.
Okay, madam. Thank you. Respected M.M. Naik Garu, Commissioner of Collegiate Education, Dr. Nagamani Madam, Principal Garu, Professor G.B.Reddy Garu, Professor Vijayalakshmi Garu, Dr. Sai Babu Garu, Dr. Lakshmi Garu, Dr. Subramanian Garu, all faculty members, teachers, and all the participants. I am thankful to Dr. Dasari Narayan Rao Degree College for giving me this opportunity to interact, to participate in this webinar. I hope I am audible. Okay, madam. Then to eminent speakers who are experts in law, not only experts in law, they are also experts in this particular area of the webinar, intellectual property rights, and they have made elaborate presentation. Their presentations are very comprehensive. After these two prominent speakers presenting about intellectual property rights, another person is presenting something means it is just like after sumptuous dinner, maybe serving a little bit sweets or ice cream, something like that. I hope my presentation also will be very simple, and it will be something related to sustainable development and intellectual property rights. It will be a kind of summarizing what my earlier speakers have presented. Then I have a small PowerPoint presentation. What I thought of talking about is the intellectual property rights and the sustainable development. Already, Professor G.B.Reddy sir and Professor Vijayalakshmi madam have elaborately spoken about the intellectual property rights, what they are. Like what Professor G.B.Reddy sir has mentioned, like Kadedi Kavita Kanarham, like the expansion of the themes in the literature. In case of intellectual property rights also, day by day, these rights are expanding and they are encompassing into different fields and different activities of our life. Today, intellectual, the knowledge is not just power, it is also a property. We are living in knowledge societies. Therefore, in knowledge societies, intellectual property rights are acquiring more and more significance. Let us just see. I have already mentioned that it is a way of summarizing. So, intellectual property. What is intellectual property? It refers to creation of the mind, such as inventions, literary and artistic works, designs, and symbols, names, and images used in commerce. IP is protected by law. For example, patents, copyright, trademarks, which enable people to earn negotiation or financial benefit from what they invent or create. If we look at the nature of intellectual property rights here, the economic aspects are involved, economic benefits are involved. That means those who invent or those who design, those who create something by applying their hard work, their knowledge, their creativity, only they should enjoy the fruits of their knowledge. Therefore, intellectual property rights have something to do with the economic benefits to the creators of such knowledge or such works. Then broadly, if we see, these are the intellectual property rights claimed for. One is patents, another one is trademarks, then industrial designs, geographical indications, and copyright. Okay, patents, trademarks, industrial designs, geographical indications, and copyright. Then if we see the patents, a patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something, or offers a new technical solution to a problem. In principle, the patent owner has the exclusive right to prevent or stop others from commercially exploiting the patented invention. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the patent owner's consent. So this is primarily, this is one important intellectual property right is the patent. Nowadays, whenever in academics, whenever we apply for anything, in applications also we find whether you have claimed any patents or you have created any patents. A country is having more patents means this is also indication that that country is progressing, prospering, that so much research is conducted in that particular country, and people are really working hard in the country. Then this is the patent. Patents are given for the inventions. And then trademarks. Trademark is a design capable of distinguishing the goods or services of one enterprise from those of other enterprises. Trademarks are protected by intellectual property rights. So whenever we look at some products, we look at the trademarks. For example, these are some trademarks. Mahindra, when we look at Mahindra vehicles, we look at those trademarks, or Bata, Bisleri, Tata. Yeah, these are all trademarks. Then industrial designs. There are also different types of industrial designs. In legal sense, an industrial design constitutes the ornamental aspect of an article. An industrial design may consist of three-dimensional features such as the shape of an article, or two-dimensional features such as patterns, lines, or color. In principle, the owner of a registered industrial design or of a design patent has the right to prevent third parties from making, selling, or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. So one industrial design, if it is copied by some others or reproduced by some others without the permission of the particular owner, then they have the right to prevent them. So these are some examples. We are very much familiar with Nokia phone, and Nokia phone has a particular shape and there are certain other products also which are identified with some particular designs. And then geographical indications. Geographical indications already Madam has mentioned about Banginapalli mango. Similarly, Professor G.B.Reddy sir has already mentioned about Tirupati Laddu and also Guntur Mirchi or Darjeeling tea, Assam tea, or Kashmir apples. Like that, there are different products which are associated with different geographical locations. So consumers go by from where these are produced, and therefore these geographical indications has value. Therefore, these geographical indications are also protected. For example, a tea powder which is not produced in Darjeeling, which is not having such taste or such a quality, but it is claiming to be the Darjeeling tea. Those who are having such a opportunity to market such a tea of Darjeeling, they have the right to protect the Darjeeling tea, and they have the right to prevent others who are misleading the public. So these are the geographical indications. And copyright. Copyright is the right that is given to the original producers of the work or original authors. Authors means here those who are creating a work. A work may be a novel, or it may be a book, any other type of the book, or it may be a film, or it may be music, it may be any literary, dramatic, artistic work. In all such works, the ownership is given to the person who has produced the work by applying his or her creativity, knowledge, and hard work. Then these are broadly the 5 types of intellectual property rights which are very much used and which are very much relevant to us from time to time. And why we should talk about the sustainable development and the intellectual property rights? Because it has 2 dimensions. There are people who feel that the intellectual property rights contribute to the sustainable development. We cannot deny it. But at the same time, there are also people who are very much concerned that in the name of intellectual property rights, the rights of the people are taken away, the traditional knowledge is taken away, and unduly some companies, big companies, and those who have the money and the power, they are in a position to claim for which they don't have really such claims. So if we look at the concept of sustainable development, today we are very much concerned about the goals of sustainable development. This is not very new concept. Since 1987, it acquired significance. In 1980s, in view of various environmental problems, a committee was constituted, a commission, under the chairmanship of Brundtland. So this Brundtland Commission submitted a report called Our Common Future. And in this report, Our Common Future, it established the concept of sustainable development, and it clearly defined sustainable development as the development that meets the needs and aspirations of present generation without compromising the ability of future generations to meet their own needs. So this particular concept of sustainable development, it's not vague. It is not like other types of development, earlier concepts of development. Earlier, it was believed that if countries like India or Pakistan or Sri Lanka, if they transform and if they change like America, Japan, England, then that was considered to be development. That means underdeveloped countries should follow the footprints of already developed countries, and by that way, they can develop at faster rate than the developed countries themselves experienced the development. Walt Rosto's writings, Stages of Economic Growth, and also several other theories reflect this viewpoint that the underdeveloped countries should follow the footprints of already developed countries so they can develop. In this process, actually, there is also something about innovations, new ideas, new practices. It was believed that the static societies can be brought into dynamism. Static societies can be brought into dynamism by the outside interventions. By introducing new ideas and new practices in the societies, these societies can be developed. New ideas, new practices means including the new products, new methods in different fields, like in agriculture, introducing different methods, different instruments, different chemicals. So all this is the innovation, and by introducing the innovations, it was believed that countries can be developed very fast. So we talked about intellectual property rights, and the sustainable intellectual property rights are the world's concern. As Sir and Madam have already mentioned, these are not confined to just some countries, though they have some territorial limitations. Now, most of the countries are signatories of World Trade Organization. Therefore, they have the obligation to respect the treaties. They have to protect the rights of others belonging to other countries. Then only their rights in other countries also will be respected. So, maintaining that at international level means it's not an easy matter. Today, we are living in knowledge societies, and we are using new media very often. Therefore, there are so many changes. Laws have many limitations today. In view of the globalized world, for example, a cyber crime may be committed not necessarily in our country. In other country, this may be committed. So many things are done today using information and communication technologies, new media. Therefore, the scope of the law has expanded. Unless there is international cooperation, today many crimes cannot be combated, cannot be controlled. Therefore, at international level, to protect the intellectual property rights, there is an organization, World Intellectual Property Organization, WIPO, and this organization also claims that sustainable development and intellectual property rights, there is an inseparable relationship, and sustainable development is very much supported by the intellectual property rights. So the UN Sustainable Development Goals provide an ambitious roadmap for human progress, and innovation is essential to meet these goals. And these innovations are very much encouraged by the World Intellectual Property Organization. WIPO Director General Francis Gurry said, intellectual property as a policy exists to create an enabling environment for and to stimulate investment in innovation, to create a framework in which new technologies can be traded around the world and shared. The economic imperative at the heart of innovation is fundamental to the process of societal transformation that the Sustainable Development Goals aim to achieve. So, if we look at the goals of sustainable development, they aim at achieving the economic development, and these innovations also protecting the intellectual property rights and encouraging the innovations also will lead to the achievement of the goals of sustainable development. Then what is the link between innovation and economic transformation? The link between innovation and economic and social progress is well established and is expressly recognized in SDG 9. The SDG 9 means Sustainable Development Goal 9. Actually, there are 17 Sustainable Development Goals. From 2001 to 2015, there were Millennium Development Goals. There were 8 goals of Millennium Development. And from 2015 onwards, the Sustainable Development Goals came into existence. And world countries today are aiming at the goals of sustainable development. These goals of sustainable development for the world countries are just like the directive principles of state policy. World countries are today aiming at achieving the goals of sustainable development. Then, if we look at the relationship between intellectual property and innovation also, Madam mentioned that intellectual property rights assumed significance from Industrial Revolution. Before Industrial Revolution, actually, these intellectual property rights were not protected. 200 years ago, innovation success was largely a matter of luck. Today, the global IP system makes innovation a systematic and reliable endeavor by providing a set of rules and processes that are applicable to all. The global IP system is a framework of treaties, laws, policies, and procedures that protects and monetizes the fruits of invention. Those who are engaged in invention, actually, they get motivation when their hard work is rewarded. So the intellectual property organization, the WIPO, it is contributing for protecting the intellectual property and encouraging the innovation. Then how this World Intellectual Property Organization contributes for promoting the intellectual property rights. It has 4 pillars of work to support innovation, international law and policy. So the countries are part of the agreements, treaties, therefore they have to respect this international law and policy towards the intellectual property rights. Then global IP services. So this organization also provides intellectual property services to the concerned organizations, countries or persons. Then cooperation and capacity building, knowledge resources. By maintaining all these things, World Intellectual Property Organization is contributing for strengthening, supporting, encouraging the intellectual property rights. Then if we look at the goals of sustainable development and innovations, World Intellectual Property Organization, it's not only SDG 9, other sustainable development goals are also very much supported by the intellectual property rights. These rights are contributing for achieving other goals of sustainable development, like the goals 2, 3, 6, 7, 8, 11, 13. For that matter, if we look at the goals of the sustainable development, no poverty. No poverty. So overcoming poverty is the primary goal of sustainable development. Madam has already mentioned that these intellectual property rights will ultimately contribute for the economic development. When the economic development is going to take place, automatically that will contribute for eradication of the poverty and overcoming the poverty. Then zero hunger, good health and well-being. It is also mentioned that For good health and well-being, inventions are very important. When inventions are taking place and when such inventions are rewarded, then people are engaged more and more in such research, and that is how that leads to the good health and well-being. Then for quality education, for gender equality, clean water and sanitation, affordable and clean energy, decent work and economic growth, industry, innovation and infrastructure. Actually, ninth point is given utmost importance when we talk about the intellectual property rights and the goals of sustainable development. Though the ninth goal is directly connected, other goals also are indirectly connected to the intellectual property rights. So whether it is reducing inequality, sustainable cities and communities, responsible consumption and production, climate action, life below water, life on land, peace, justice and strong institutions. 17th one, partnership for the goals. So here also, if we look at international law relating to intellectual property rights, the partnership, that is very important, and world countries, they share some common interests, and they respect the treaties, and they contribute for protecting the intellectual property rights in their respective countries. So this is one dimension, that the intellectual property rights are contributing for achieving the goals of sustainable development. And another dimension is that environmentalists, particularly some environmentalists like Vandana Shiva, I'm also very much inspired by her writings and her speeches. These are very much available in YouTube. She is very much concerned how the seeds are patented. Seeds are patented, and how that kind of patenting by big multinational companies like Monsanto and other such companies, how they are trying to take away the rights of farmers. And by taking away the rights of farmers and by introducing some new other practices, then that is leading to the over expenditure on part of the farmers, and farmers are becoming bankrupt, and they are finally ending with the losses and sometimes even committing the suicides. This is all because some big companies, they are trying to claim intellectual property rights on certain things on which actually they should not have claimed, and the government should not allow this kind of means occupying different things. Sir has mentioned about Ongol bull patent being claimed by Brazil for Ongol bull, and like that for many such things, for traditional knowledge. This is not really the knowledge of some big company, but they are trying to take away, or they are trying to grab certain things which are there already in the developing countries, and they are claiming that. So that is really counterproductive when we look at it from sustainable development point of view. But interestingly, globalization, privatization, liberalization, and also sustainable development, these two are parallelly progressing. On one hand, we see liberalization, privatization, globalization with motives that there should be more and more amassing of the wealth. Opportunities are given to the industrialists to amass the wealth. Liberalization is done. Nowadays, if we see also, lot of privatization is going on even in our country. So this is one phenomena that is going on. Over exploitation of the natural resources. Obulapuram mines. There were allegations that Obulapuram mines were over exploited. Like that, this privatization, liberalization and globalization, that is leading to over exploitation of the nature, and that is further leading to the scarcity of the resources and environmental pollution. Therefore, today this is also time for the intellectuals the world leaders and the administrators to think about these two things and create the balance and to give importance to the lives of people and more the rights of people. So this is about the intellectual property rights and sustainable development. Broadly, there are two angles. One is how the intellectual property rights are promoting the sustainable development and how the intellectual property rights are also trying to take away the rights of the people and the traditional knowledge, how unduly they are claiming the traditional knowledge as their knowledge. I'm profusely thankful to Sri Dasanarayan Rao Degree College, Madam Garu, Nagamani Garu, Dr. Saibab Garu. I'm thankful to my panelists. It's a really very good learning experience to me from Professor G.B.Reddy sir and Professor Vijayalakshmi madam. Thank you all. With these few words, I'm stopping my presentation here.
In fact,
సార్ మాట్లాడండి సార్ సాయిబాబు గారు.
is not on us. Is it
Sai Babu sir,
audible?
your network connection is low, sir.
Low. Okay. Okay. 1 minute.
Lakshmi madam.
Subramanya garu, is it okay?
Sir, please continue. Sir. Please continue.
Yeah. In fact, yes, management without sustainable development to any nation only a development, sustainable development aspect, not only two parts on which Professor B.Balaswamy ఒక్కొక్క ఉంటే
Sir, your network is very low, sir.
BT.
Voice cut out on the.
Sir, shall I continue with concluding remarks?
Please, madam.
Okay. Thank you all, sir, all three panel members for providing rich inputs, sir, during this webinar. First, I want to mention keynote address of Professor G.B.Reddy garu. His presentation is laced with delicate humor and supported by abundant examples, sir. His statements, knowledge is property, a copyright is right to copy one's own work, Kadedi patents Kanarham, summed up the theme in a lucid way and really gave a very clear picture of intellectual property rights, particularly to the students, sir. And then the examples, they are ranging from Guntur Mitch to Anko Mouse, from Tirupati Laddu to Michael Jackson, immensely helped the audience instantly connect with the theme. And the 4 types of intellectual property rights also very easily, sir. Examples of a school dropout getting 2 patents for creating 2 filters in Mahindra and Mahindra. An unknown farmer getting patent for creative distinct variety of rice. An illiterate artisan inventing a machine and getting a patent will definitely inspire students, sir, with innovative spirit to pursue research. Stating that IPR is omniscient, he emphasized the need of demystifying it. It is true, sir, so many misconceptions are there. It is high time to demystify the concept by citing the example of multifaceted personality of Dr. Dasan Narayan Rao. Professor G.B.Reddy garu made our college proud, sir. And our sincere thanks to Professor G.B.Reddy for presenting a comprehensive overview of intellectual property rights, sir. Coming to Professor Vijayalakshmi Madam Garu, I think she talked elaborately, sir, on actually in the industrial copyrights and industrial, that is, I think she made a distinction between industrial thing, that is inventions and expressions, I think. And secondly, she talked about copyrights, sir, and she gave a very detailed presentation mentioning all even procedures also for applying patents. And her statement, even a single sentence with originality can be registered for copyright. And really, sir, it showed the implications that are there in intellectual property rights. And again, she mentioned some film industry and then music industry also. And the statement that made by her, sir, it puts in nutshell the whole concept of intellectual property rights, that is, the more IPs, the richer the country. I think it puts the whole thing in nutshell. And I thank Vijayalakshmi Madam for presenting the all the implications that are there in intellectual property rights, which can reach especially the student community, madam. So once again, I am thankful, sir. Then I also, and then coming to Professor Balaswamy Garu, we are pleased, sir, to meet you once again on virtual platform. Earlier, you made presentation when we hosted webinar on impact of COVID on human relations. And we are pleased that you once again accepted our invitation. And you, at the beginning of your presentation, you said yours will be a snack after sumptuous meal. It is not so, sir. Actually, it is an additional input, sir. We find it as an additional input because your focus is always on sustainable development goals. So it is very relevant, sir. And you have really rightly pointed out that it is directly, though it is directly connected to SDG 9, actually it is connected to all sustainable development goals, sir. Even I think so. The intellectual property rights, it is directly connected to all sustainable development goals because it is related to, everything is related to economic progress, sir. So you have rightly pointed it out. And then again, you have mentioned the that is the other side of the coin, that is how some people are suffering due to the infringement of property rights. And you mentioned Vandana Shiva's laudable efforts in fighting for the rights of farmers, sir, that is environmental, towards environmental protection. So there will be both sides of the coin always. So it is convincing that you have mentioned the other side of the picture also, that is how if the copyrights are not protected and how the piracy takes place, how the genuine creator will suffer, sir. So in that way, that is a really rich input that is provided by you, sir. So these are my remarks on the 3 presentations during this webinar. Now I request Dr. P. Sai Babu Garu to present vote of thanks.
Thank you very much, madam. In fact, this webinar is a great experience to all of us. All the three invitees are really professionals in their own. So I'm really happy. Professor Balaswamy garu చెప్పినట్లు ప్రభుత్వాలు ఖచ్చితంగా ఇటువంటి రైట్స్ మీద లేకపోతే WTO లాంటి ఒప్పందాల మీద సంతకం చేసేటప్పుడు దేశం యొక్క ఆసక్తులు ఇంట్రెస్ట్లను ఖచ్చితంగా పరిరక్షించాలి. I remember S.R. Shankaran, he was the only one man who reluctantly refused certain aspects of WTO. మన విద్యుత్ బిల్లుల వినియోగము ఇట్లాంటి వాటి మీద గ్యాట్ టు WTO, అలాగే విదేశాలు మనకు రుణం ఇవ్వాలంటే వాటి మీద ఒప్పందాలు సంతకం చేయమన్నప్పుడు ఆయన 2 days ఈ వెయిటెడ్, వదిలేశాడు అంతే. పర్టికులర్ గా మన కండిషన్స్ ఒప్పుకుంటేనే తప్ప హీ డిడ్ నాట్ సైన్ ఆన్ ది అగ్రిమెంట్. సచ్ ఆర్ ది పీపుల్. అటువంటి వాళ్ళు ఉంటే ఏ ప్రభుత్వం అయినా ఏ దేశమైనా చాలా ఇదిగా ఉంటుంది తప్ప ప్రతిదాన్ని నేను ప్రైవేటైజ్ చేసేస్తాను అనేటువంటి పరిస్థితి ఉంటే రాబోయే రోజుల్లో చాలా కష్టమైనటువంటి పరిస్థితులు ఎదుర్కోక తప్పదు. ఏది ఏమైనా ఇటువంటి డిస్కషన్స్, such platforms would certainly go a long way in enlightening not only the academic community but also the student community and the scholars. Thank you very much. I thank Professor G.B.Reddy garu for his wonderful keynote address. Thank you very much, sir. I also thank for her variety of aspects covered in her lecture. Thank you very much, madam. Madam ni naku Seeta madam introduce చేశారు. Seeta madam నేమో మా ఫ్రెండ్ డాక్టర్ ధనరాజ్ గారు ఇంట్రడ్యూస్ చేశారు. I thank both of them. అలాగే ప్రొఫెసర్ రెడ్డి గారిని ప్రొఫెసర్ బాలస్వామి గారు ఇంట్రడ్యూస్ చేశారు. సో దీపం వల్ల ఇంకొక దీపం వెలుగుతున్నట్లుగా కొంతమందిని మాకు ఇట్లా పరిచయం చేయటం వల్ల ఇట్ ఈస్ ద కాలేజ్ is richly benefited and also our student community is richly benefited. Professor Balaswamy is a good friend of mine. He is like my younger brother. So I thank wholeheartedly for supporting in all the causes of our village. Without whose support and encouragement, we could not do this type of activity. He is none other than our commissioner, M.M. Naik garu, who has given a free hand to conduct this kind of webinars. And our dynamic principal, Dr. Nagamani garu, without whose cooperation, we could not complete this kind of, or could not conduct this kind of webinars. Srimati Lakshmi Madam, Department Head, Commerce, and also Amita, Commerce Department, Srimati Jerina Madam, Telugu Department, and other my colleagues who have supported in this cause are really should pay my thanks to all these people. Technical advisor Subramanian garu is always supporting our cause. Thank you, Subramanian garu. Alage Srinivas garu, my friend, one of our good, and also our JKC mentor. All these three people, they deserve a big thanks from our college, and I wholeheartedly thank all these people. Externally and internal support, technical support to this webinar for the smooth conduct of this webinar. Thank you very much, and we look forward to your guidance and participation in coming days. Thank you very much. declare this webinar is closed.
Let's end the session with national anthem. Thank you.